electronic devices. There's apologies from Sammy Douglas and Patsy McGlone, and I know some other members will be arriving a little bit later. There's draft minutes of the meeting held on the 11th and 12th of November, and if members are content with their accuracy, I will sign them accordingly. Agreed. There's no matters arising from those minutes of the meeting, but Mr. McGuinness.
Just one issue, Chair, I would like to raise. We conducted the inquiry of sorts into NIJAC. Certainly issues arose in relation to NIJAC. I do note at the moment that there is a competition for the appointment of 3 High Court judges, and it might be useful to obtain a report from NIJAC in relation to the procedures and outcomes of such a competition. I think that might be helpful because it could inform any future inquiry that we do into NIJAC, which of course is within the contemplation of this committee and has been for quite some time, although we've had an awful lot of other work.
Yeah, well, the committee has agreed to have the secondary inquiry, which has to be done before the end of this mandate. So I'm happy if members are content, we'll write to NIJAC, to the chairman of NIJAC, indicating we would want to know the procedures that are being followed and the outcome of that, and that will be part of our deliberations into the inquiry. If members are content that we do that? Agreed. Agreed? Agreed. Okay. Then this item is the October monitoring round, and it's on pages 16 to 49, and let me welcome Nick Perry, Permanent Secretary, Glenn Capper, Deputy Director, Financial Services Division, and Mark McGuicken, Deputy Director from Public Legal Services Division, all from the Department of Justice, and you're all very welcome. This session will retrospectively be Hansarded and published in due course, because obviously they're not here. So you're very welcome, and I appreciate Mr. Perry, obviously at short notice, making yourself available to come and speak to us today. I think it was important that you were here to do that, to allow some questions to be put to you that maybe others mightn't be in a position to fully answer, given it's more political in nature, how these allocations come about. And you mightn't be able to even answer on behalf of the Minister, but nevertheless, you are all very welcome to the meeting. So I'm going to hand over Mr. Perry to you at this stage.
Well, Chair, thank you very much. The committee has asked for details about the October monitoring allocations made by the Department, which total £29 million, and I think you have the paper we provided the committee with a few weeks back. I think it's important at the outset to highlight the difficult financial environment and uncertainty that all departments, including the DOJ, have been operating in this financial year. At the beginning of 2014-15, recognising the pressures facing the department, including legal aid, we took steps to make additional internal savings and reallocate funding within our ring fence to achieve a balanced budget. This is something the department has successfully done for the past 3 years. Despite having to manage a significant legal aid demand-led pressure, we've absorbed pressures and lived within our budget that is reduced by 7.2% over the 2011-15 period. It was clear from the start of this year that we would face a significant legal aid pressure of over £30 million. In presenting its June monitoring position to the committee, the department reported that it had allocated £23.5 million to the Legal Services Commission towards that pressure. We also noted that we would bid for the remaining legal aid pressure, and in total, therefore, the department's bid to DFP as part of June monitoring was £19.7 million. Subsequently, it became apparent that the department's budget would be reduced, with the DOJ ring fence effectively lifted. The department's budget was cut by 4.4% this year, equivalent to over £47 million, and this was a new pressure to be absorbed in year. Chair, perhaps I could then turn to the position with legal aid reform. It is true that legal aid expenditure continues to run above the available budget. The budget this year is £75 million, and expenditure is running at an estimated £109 million. That doesn't mean that the reforms we've introduced so far have been ineffective. The pressure would be even greater if these had not been introduced. The committee is aware of the savings already delivered, amounting to around £19 million a year on the criminal legal aid side. In the Crown Court, for example, the removal of very high-cost cases will save in the region of £14 million a year, and further reforms are in the pipeline. However, the legal aid landscape in 2014 is not the same as in 2011. This is a complex area that is constantly changing. Expenditure on criminal legal aid is running at about £54 million this year, about the same as in 2010-11, but that reflects a 30% increase in Crown Court cases going through the system last year. That volume increase has masked, I believe, the underlying reduction, and as the numbers drop down again, I expect to see the benefits of the changes reinforced by the additional reforms we're introducing. On the civil legal aid side, however, there's been a significant increase since 2010-11, as the committee is aware. We will be starting implementation early next year of a range of measures to reduce civil legal aid costs by £13 million a year, and I think Mark has briefed the committee on that. As the Minister has said, it is very unlikely that reforming fees and reducing administration costs will in themselves completely bridge the funding gap, though they will greatly help. The current system is not affordable at £75 million, and the pressures in the system are always to drive costs up as new areas open up. The system needs to be fundamentally redesigned, and Jim Daniels' current review is intended to assist in doing that. There will be difficult decisions to be made about scope and eligibility as we go forward, particularly given these further significant cuts in prospect, not just next year, but in the years beyond. Turning now to the position following October monitoring. At October monitoring, as the committee knows, the Executive allocated £29 million to the DOJ for PSNI and for legal aid pressures. Proposals for allocating any resources are developed by the Department's Strategic Resources Committee, which I chair as accounting officer, and which comprises the 4 directors and the 2 independent board members. Those recommendations go to the Minister for decision. The proposals are developed taking various factors into account: statutory obligation to pay, operational necessity, ministerial priorities, and the capacity of individual organisations to make savings depending on their size and the structure of their budget. This year, they were also informed by the Minister's bilateral meetings with the Chief Constable and the Policing Board, the Chair of the Probation Board, the Police Ombudsman and others. October monitoring allocations were made on this basis, the legal aid amount based on the bid considered by the committee in June. And I think the details of the particular allocations are in the annex to the paper the committee has. These allocations were primarily made to offset the most severe impact of cuts and where there was a real risk of savings not being delivered. We are continuing to work closely with all the spending areas on almost a weekly basis to monitor spend as the year continues, and we will keep the committee informed on that. Chair, that's all I wanted to say by way of background. In terms of any specific detailed questions, of course, Glyn is the expert on that.
Okay, well, I appreciate that. Thank you very much. In terms of the 29 million and that the Executive allocated, I note that the Justice Minister didn't want it, certainly didn't vote for it, but nevertheless got it. That 29 million, the 13.2 million given to the Legal Services Commission to deal with legal aid, the Minister has highlighted that he was under contractual obligations to pay that, although reading the paper that's been submitted to the committee today, I don't see any mention of contractual obligations, just that if it hadn't been paid there would be implications for access to justice and potentially on solicitors and barristers. Can you answer that question about the contractual obligations forcing the Department to allocate 13.2 million on legal aid?
Well, Chair, it is a demand-led area. There would be the consequences you've described if the money wasn't forthcoming, but the work is done. It is done under the terms of the relevant legislation, and Mark can provide chapter and verse on that. So it is effectually an obligation.
In effect, Chair, if I may add to that, the Legal Services Commission will receive bills from solicitors and barristers for work which has already been completed. And if the resource wasn't available in year in order to pay those, that's a contractual, there's a requirement there to pay those valid bills once they've been validated, and they go through a process of validation as you would expect. And once they're a valid bill, then they need to be paid. If the resource wasn't available in year, it would have been necessary to slow down payments and actually push that expenditure into the following year. But it would still have to be paid at the end of the day.
So the answer to the question is it could have been slowed down and it could have rolled into the next financial year?
There is a degree of flexibility about the timing of payment, yes. But it simply increases the problem next year if one does that.
Yeah. Has there been any slowing down? Does the 13.2 million cover all of the demand-led pressure, and therefore there won't be a slowdown in the payment of legal aid?
For two reasons, the Legal Services Commission have slowed down have reduced their targets slightly in the current year. One is because of savings in their own internal budget, and they had to let a number of staff go as a consequence of budget reductions within their own area. That has an impact on their ability to process payments, so their targets have moved by about 2 weeks in certain areas, and that will have the effect of slowing down some payment in year, yes.
But there won't be any denial of access to justice, and there won't be any solicitors or barristers' practices put at risk as a result of getting this additional 13 million. Now that risk has been dealt with.
There is always still a risk in terms of some of the life cycles of legal aid cases are quite long, and there's a period of time before those bills are submitted. So I couldn't actually say whether there are any firms of solicitors currently in a position where even the smallest of delay in reaching payment would put them over the tipping point. There certainly are a number of requests made from time to time to the Legal Services Commission for payments to be made urgently in cases of hardship.
I suppose my next question that leads me to, how did the department prioritise how this allocation was split up in terms of the 29 million? Because legal aid gets 13.2 million, which could have been delayed and rolled into next year, taking into account, yes, it would have had an impact on, and you would have to pay it eventually. But then I read about the cuts on the police service, police recruitment plans, community policing, combating serious crime, and then also legacy investigations, which have all been impacted immediately. Now, I noted the Minister didn't campaign for more money alongside barristers and solicitors. He campaigned alongside the Chief Constable on the grounds of public safety. And yet, when it comes to his allocation, the police service get less than barristers and solicitors. Now, I would want to try and get a better understanding of how was the prioritisation and criteria used that meant the police service actually got less when it came to this 29 million, which the Minister actually didn't even want.
Well, as I said in my opening remarks, Chair, there are the approach the SRC, the Strategic Resources Committee, takes to this issue and took to this particular issue was threefold. One, operational necessity. Two, legal obligations to pay bills, and thirdly, the capacity of organisations to cope with savings. And on the back of that, on the back of very detailed exchanges with the police, as I said, not just the Minister's meeting with the Chief Constable, there is a monthly Departmental Policing Board and PSNI meeting to discuss resource issues, but I also see the Chief Constable every couple of weeks and often more frequently than that. So we had a very clear sense of the difficulties facing the police, and I greatly regret the fact that they are facing those difficulties. But the police do represent something like 2/3 or more of the DOJ's budget, and there's no way that they can be entirely protected. The judgment here was not all the LSC's requirement was met. There's always an end-year issue about some bills may fall into next year, even despite this allocation. Equally, if we got more money now and the police didn't need it, we might be able to bring some bill payments forward on the LSC side. But the judgment here, based on the conversations with the police, was what they would be able to cope with while continuing to meet their core requirements for keeping people safe. And I absolutely accept there has been an impact across a whole range of capabilities.
So the police service signed up to the 13 million. Did they say we're content with that?
No.
Well,
no, they didn't say they were content. They've said, the Chief Constable said to me that he will do his best to live within it, and we are in pretty well weekly contact with the police about how they're doing.
And did the Minister then, I take it, accept that it was satisfactory to cut frontline policing in order to protect the legal aid budget?
No, we didn't. It doesn't regard it as satisfactory at all to cut frontline policing, but it is the obligation to meet this demanded expenditure which the department doesn't control. It can to some extent regulate or influence the timing of payments. But in terms of these bills for work previously carried out, there is an obligation to pay, as Mark has said.
I still can't understand, though, and maybe that's a lack of capacity on my part. Still can't understand why the department could have delayed legal aid, could have restricted the payment of legal aid, and more money would have went to the police service, so that mitigation could have taken place to avoid some of the consequences that the Chief Constable quite outlined very graphically in public, which the Justice Minister stood shoulder to shoulder with the Chief Constable about. But when it came to the actual allocation, he gets 29 million and he only gives a third of it to the police service. And yet the campaign for more money was primarily based upon the needs of the police service. So what was said publicly by the Minister and the Department isn't reflected in the reality of the allocation. And I'm struggling to understand the rationale to justify that.
Well, the rationale is that the legal aid element of this is demand-led, and the department has an obligation to pay it. But of the balance, virtually all of it, 13 million out of 15 million, or whatever the figure is, went to the police. The police are our number one priority once we've got past obligations that we are required to meet.
Okay. I'll bring some other members in. Mr. Dixon.
Chair, thank you. Can I ask you, Mr. Gray, what are the consequences of not paying those approved points on the legal aid bills when they come in? What would the consequence be if you simply not paying one or substantially delaying one into the next financial year?
Well, there are a number of consequences, and Mark can probably add to this, Mr. Dixon, but clearly there is there's a risk of legal challenge, from the firms affected. There is.
Would that lead to additional legal cost to yourselves?
Yes, there is that risk. Yes, it could also, of course, as the chair mentioned, have a direct impact on particular firms depending on their financial circumstances. So there is a clear a number of potential impacts, but there is a clear risk of legal action, as you say, additional cost arising from that.
And what effect has the delay by this committee and the Assembly to bring forward legal aid reforms impinged on these costs to us?
Well, we've been very grateful, of course, for the support of the committee and a number of the measures that have gone through to date, and we've already mentioned some of them. A couple of measures have been held up, and I know there's one measure I think still that the committee is still considering to do with financial eligibility, which I think could save around £3 million a year on the civil side. So if it were possible to move that, that would assist us, without doubt.
And would it be likely that £3 million would then be freed up to go to the police?
Well, so given the operational pressures, the Minister's priority is frontline services, so that would be his priority.
Thank you.
Mr. McCartney.
Thank you very much. In the process of making a bid, had you a figure that was required for contractual obligations, or was that just a projected figure?
Well, it's a projected figure based on the bills that we expect to see coming through the course of the year, looking at the number of disposals. There's a complex process in terms of working out the forecast across all of the various legal aid categories, and with criminal and civil, there are quite a few of those categories. So there's a projection based on the bills that we know that are coming in and which are sitting there ready to be assessed. There are bills sitting with the taxing master, and those tend to be the bigger ones, which are we know are in the system as well. So you can have a fairly good estimate at various times during the year of what you'd expect the final outturn to be at the end of the year.
At the beginning of the year, in terms of the budget projection, was that then a failure of proper budget projection?
No, I think the budget projected, the projections at the start of the year are pretty close to where we currently are. I think the fundamental flaw there is that the availability of the budget in the baseline flowing from devolution can't meet that current demand.
Okay. But I mean, one of the, if you like, observations made about the Legal Services Commission was, nearly their continuing inability to have the budget predicted properly. Was that part of the reason why this bid has to be made in the October monitoring round?
No, there was no impact in terms of in year. There was an impact in previous years in terms of, in particular, in relation to the additional throughput within the criminal side as a result of the appointment of the additional Crown Court judge. But in this year, I think there was a lot more work has been put into working through the forecast, ensuring that because you have got to make a range of assumptions in coming to that forecast, ensuring that those assumptions are well founded and you use the best evidence base that you have. We've also, the process is enhanced now by engaging earlier and better with other bodies such as the court service, such as the public prosecution service, even going back to the police to see where things are currently sitting. There is a degree of demand-led in it, and there's a degree of volatility in it. But I think in terms of this year, the original budget projections were fairly accurate. The forecasts were fairly accurate. The budget, sitting as it does, is currently insufficient to meet those full forecasts. And I think, to its credit, what the department sought to do was to work internally to find ways of meeting the excess, and did provide additional resources earlier in the year to the Commission to go part of the way towards that, recognising the forecast.
And the changes now with the new bill, the Legal Services Bill, do you think the predictions will be better, and so the need for, which is a sizable amount of money in an October monitoring round, will be reduced?
Well, what's going to change the demand is reducing the scope and reducing the level of payments. The forecasting, I think the approach that we've got now, we can certainly build on it and continue to do that, but it is in fairly good shape.
And in terms of the bids that you make on behalf of the agencies, what input have you got then when, say, like the police service make an application? Can you make any recommendations to them where that money should go, or is that wholly a matter for them?
Well, once we allocate a particular sum to the PSNI, it's a matter for the Chief Constable's operational decision how he allocates that.
Yeah.
But of course, the quantum is based on discussions with the police service about where their particular pressures are. So there's a kind of expectation that it would go to those areas.
So there'll be no ability, say, like if the Chief Constable comes to the department and lists 6 headings and say that we need extra money to work in these 6 headings, and the department comes up with some of the money and says, well, that's the 3 priorities which we would like. You have no input in that?
Well, it might form part of the discussion that the Minister has with the Chief Constable, but at the end of the day, we can't direct these two.
In terms of this particular process, when it came to the allocation for legacy cases, did you have any discussion with the Chief Constable around that?
No, the Chief Constable mentioned that when it came to allocating funds, what his priorities would be, and they were current front, recognising the obligations he also has to legacy cases, that they were likely to be to frontline pressures, but that was a decision for him, and particularly in discussion with the policing board.
And did you make any observation, that sometimes dealing with legacy cases, if they're not dealt with efficiently, then there's a public spillover which can then have a wider effect on public confidence? You had no view, or you just say that?
No, well, we have a view, and I think as we mentioned the last time we were up before the committee, was regarding clearly there is a knock-on effect on the families who are affected and their confidence in the system. Equally, there's a confidence issue about being able to respond to the here and now, and at the end of the day, the judgment about how that was allocated by the Chief Constable within his budget was a matter for him.
Would it surprise you that when there is an additional allocation, that there's no additional allocation to legacy cases?
Within PSNI?
Yeah. As a result, I mean, the Chief Constable made the initial decisions on the budget that he was given, and then he made the announcements of what he believed was the things which the PSNI couldn't cover. So the department, on their behalf, makes a bid and they get extra money. And yet when they get extra money, they don't seem to make any percentage increase across the range of issues Would that have surprised you when you do accept that there is a public spillover in relation to these cases?
It doesn't surprise me to the extent, Mr. Crowley, that the Chief Constable had indicated that he would try to keep meeting his range of obligations across the piece, but that his priority would be immediate operational pressures. But as I say, that beyond that, the Department is not able to input into where particular bits of money should go.
Okay, thank you. Mr. Frey?
Yeah, thank you, Chair. Can I ask, with regards to your opening budgets for the Northern Ireland Legal Services Commission, there was revised in your savings of 6%. Where does that leave it now with regards to the October monitoring round?
If we look at the Commission's budget from the start of the year towards its now, overall the Commission has had a net allocation of about £32 million. As you said, factored into that were cuts of 6%, about 4.5 million, with a gross allocation of 37 million. So there are those two elements to the Commission's in-year movements, and allocation and then cuts. The net result is that the current Legal Services Commission budget is about £107 million, and as Mark mentioned earlier, that is considered sufficient to meet this year's payments based on the current payment targets.
So what does that leave? What does that work out in a percentage term with regards to the start of the opening budget to now, or to the end of this financial year? What will that leave it at?
Well, the opening budget was 75 million, closing budget was 107 million, so that's a 32 million pound or so increase, which I think is just over 40%, 43% of an increase from the 75 million starting point.
Sorry, repeat that again. 40%?
So the budget started at 75 million, it's now 107 million, so it's a 32 million increase from the 75 million starting point.
So just so I can get the quantum of this, that aspect of the department's spending has risen by 40%, but yet other branches within the organisation, forensic science, for instance, has taken a 37.4% cut.
Just a couple of comments on that. Firstly, I'm not sure I would describe it as that bit of the department's budget has risen by 43%. I think what we can say is that the budget has had to increase by that amount to meet as Mark have said, the demand requirements. In terms of the forensic science budget, we always comment when we're talking about the forensic science budget to the committee that there's a slight work of the percentages there, because the budget that you have in front of you is the forensic science net budget. Forensic science generates most of its income from police and spends in the region of £8 million or so. And so it spends 8 million, gets 8 million in. There's a top up, if you like, from the department of £500,000. There's been a net movement of about £200,000 of a reduction, and that's where you get a peculiarly 48%.
Correct. Begs the question then, if income's 8 million and outgoing's 8 million, what's the 582,000? I'm reading that as I think I'm right.
Yes,
What's that?
582,000. I'll come back to you with the specifics, but there are things in there, for example, some funding from the Department for Change Management type things within forensic that aren't recharged to police. So there's a small layer of spend that isn't recharged, and that's what that budget really is.
Maybe this question has been asked. I didn't hear it right or hear the answer, but it seems an obvious question. What if you hadn't been successful in October monitoring rounds? What if the allocation of 29 million additional wasn't there, which then 13 million was used for the legal aid? Where would we be? What would have happened if we hadn't had that? Would the ceiling have fallen in? What would have happened?
I think at one point during the year, or at actually many points during the year, we weren't sure what our cuts or what additional funding was going to come in. So at one point during the year, we had various scenarios pulled together and presented to the committee that had more or less all bodies across the system with higher levels of savings. So primarily taking into account the need for Nick to achieve a balanced budget, there would have been higher savings or cuts, if you like, across most areas.
So you would have funded the Legal Services Commission anyway, and you would just had to have taken that off other aspects of the department?
I think that goes, and I'll let Mark come in as well on this, that goes back to the point that there's only so much that you can manage in terms of the demand-led nature of payments in a year. So the significant amount of that funding would have had to be found from somewhere.
I think I can add some gloss onto that. During the year, the availability of funding and the budget changed, and issues started to crystallise in terms of efficiencies which were being required elsewhere, and the availability of the department to find additional cuts from within its other budgets in order to meet the legal aid demand. And just prior to that allocation coming forward, the Legal Services Commission had to take the unusual step of writing to the Law Society and the Bar Council to advise them that in order to live within the budget which is available to it at that stage, it was reducing the weekly payments being put forward or being processed. As a consequence of that, both the Law Society and the Bar Council wrote directly to the Minister to seek a very urgent meeting with them. And in advance of that meeting actually happening, the additional budget allocation was made available. So clearly the profession, the legal profession, were extremely concerned at the potential consequences, and they would have been making those arguments very strongly to the Minister.
If the additional funding hadn't been clearly, it would have been very difficult for every part of the department, and legal aid would probably have taken an additional hit, but the consequences might have been of the sort that we were just discussing with Mr Dixon in terms of legal action and the consequences of putting more pressure into next year.
Excuse me for my ignorance, and I genuinely don't know, but if a builder does some works on a premises, he should expect payment within 30 days, sometimes 90 days, some days, sometimes longer than that even. How does a solicitor or a barrister get paid? How long did they expect to wait before they're paid?
Well, there are a variety of approaches involved, but quite often a bill will be received, which will have to be assessed, and further information will be required. So it's a process that the Legal Services Commission will go through to get the necessary information to validate the bill and to authorise it then for payment. Certain cases go to a judicial figure, the taxing master, who will assess the bill and then send it through to the Commission for payment. And in effect, when he sends the bill through, it's a court order, and there's a 4-week turnaround required on that. If the Commission don't have the processing capacity to do all of the work which they need to do, then there can be a delay in actually getting those bills processed, and that's where the target dates have slipped out. There are some cases where there are high volume of very small amounts of money, and they take time to go through the system. Others are bigger cases, bigger amounts of money, which need to be checked through, and some of those can be done more quickly. But for each of the categories of case, and I don't have the figures in my head, but they are published in the Legal Service Commission's business plan. But part of the issue is if the bills are stacking up in the cupboard and there's nobody there to actually process them, then the delay increases.
And final question, Jabba. Would it be inconceivable to have given the Commission 6 million on part pay until the new financial situation, the new financial year? Or is that pie in the sky? Is that
No, it's not. It's not pie in the sky. I mean, there is a degree of scope about the profiling of payments and the timing of payments. There are targets for the Commission in terms of payment, and there is a level of expectation in the profession about the speed at which they're paid. And there's, I suppose, a degree of judgment in about at what point that delay becomes unreasonable. But in the case this year, the judgment was taken that there should be some slowing in the rate of payment. The Commission took that view. But to push it beyond a certain point wouldn't be helpful, not least because of the knock-on effect next year.
Okay, Chair, thank you.
Just some clarity. In terms of the statutory rule on the Crown Court remuneration, which this committee disposed of on the 8th of October, when actually is the Department going to lay it in the Assembly?
The committee will be familiar with the range of secondary legislation that we're putting before it, and that draft rule is currently being drafted with the plan to lay it in December, and at the same time we're working up the business case that needs to sit alongside that with DFP. So at current plans, we hope to lay it in December with a commencement in January.
This is the Crown Court remuneration one,
Yes.
which the Minister has frequently said that the committee didn't deal with effectively, but we actually did dispose of it on the 8th of October, and you're not going to lay it until January?
Well, the order will be laid in December.
Uh-huh. Second to that, in terms of your need to consult with this committee, because the Minister has almost indicated that the committee has been responsible for not allowing some of these changes, does the Department and the Minister actually need to wait for a committee to take a formal decision on a draft rule, or can the Department lay that rule without the committee actually reaching a final decision on it?
I'm not quite sure of the technical answer to that, Chairman, but I think personally I've taken the view that it's much better to go and lay a rule with the committee's endorsement rather than having that prayed against or challenged on the floor of the Assembly. So, I mean, the committee has an extremely important role to play, and from my perspective, we try and facilitate that role.
See, I'm pretty clear on it that actually the Department doesn't need to wait on a committee. The Department didn't need to wait until the 8th of October, whenever we pushed it to an actual vote, before the Department would have been in a position to lay the statutory rule in the Assembly. All the Department needs to do is to consult, and by way of consulting, you give it to the committee, we'll meet with officials, and if some members of other parties want to procrastinate and drag things on, and other members are very keen to expedite it maybe more quickly, actually the Department can bring the issue to a head and actually just lay the statutory rule. And if someone wants to pray against it, so be it. There'll be a vote in the Assembly. So I think the Department needs to be clear whenever it's going to start accusing this committee of actually delaying things about the powers that you have to bring things to a head. And that leads me to my next question. We've got a written update today on civil legal aid, something that 18 months ago the Department first flagged up that it was going to reform, and we're only getting a written update today and we haven't got the final proposals. So when does the Department intend to actually provide us with the final proposals on something that was flagged up a year and a half ago that would save millions of pounds?
And I've briefed the committee on a couple of occasions in relation to civil fees, and we did consult in the course of last year on a set of proposals which ultimately wouldn't have been fit for purpose and were not accepted generally by the profession. And since that time, since earlier this year, we've been engaging with the profession to understand and craft a new structure. Going back to Mr. Brew's point about how long does it take to process a payment, one of the objectives that we want to do is to, as far as possible, introduce standard fees. That means that the payments can get, there's a much reduced administration burden on that. But there's a great deal of complexity within civil fees and a great deal of complexity in terms of the number and types of cases. And when you're developing a standard fee approach, it's important to understand each of those to ensure that you get the right fee set for them and you've got the right parameters set for those. That has taken us some time, and we've invested that time to make sure that we bring back to the profession, and the proposals have just went to the profession last night, and I would hope to be meeting with them over the coming weeks till we go through that, through the detail of that, and that's effectively what the update to the committee is today. And to come back to the committee with our final proposals following that further period of consultation and discussion with the profession, with our final proposals in the new year. It's important that we get it right. It's important that we set the fees at the right level so that people are appropriately remunerated, and that we also don't avoid any unintended consequences in setting that structure. It is a big piece of work, and I think personally I believe it was appropriate to invest the time in it which we have in order to get the right outcome, which will stand the test of time in future years.
Okay. Mr. Poots.
Thank you. So you're spending 75 million on legal aid? Is that right?
Sorry?
You're spending around 75 million pounds on legal aid?
No, the budget is 75 million.
Yes.
I think the spending will be closer to 107 this year.
Okay. What was it last year?
It was in the same region.
Just over £100 million, just over last year.
It's been between 105 and 109, I think, over the last 2 or 3 years.
Yes.
Last 2 or 3 years. Okay. So everything else has been suffering cuts. Justice budget was ring-fenced, so you didn't do anything about legal aid over the course of the last few years. Is that the case?
Well, the justice budget was ring-fenced, but actually within that ring-fence, our level of savings were higher than most other departments, as I understand it, at over 7%.
Sorry?
Within the ring-fence, the level of savings required of the DOJ was, I think, just over 7%, and that, I think, is higher than other departments pay.
Yes, this year. That wasn't the case in previous
That's
years.
been the case since...
I think over the 4-year budget 2011-15 period, the department's budget has fallen from its 2011 position to its this year position by 7.2%.
Okay, but obviously legal aid hasn't been falling.
Well, there are, in terms of the drivers, Mr. Poots, around legal aid, the fact that this year's figure is roughly similar to last year, the years before, disguises the fact that there was a 30% increase in the throughput of cases going through the Crown Court. So, yeah, it is still roughly the same level, and we wanted to come down, we needed to come down, but actually that figure disguises the fact that a significant volume increase has been absorbed.
Significant volume of increase in the number of legal aid applicants?
The number of cases going through the Crown Court. Yeah.
Cases going through the Crown Court. And has that led to more people in prisons?
Well, it has. I mean, at the moment...
Is there a 30% increase in prisons then, if that's the numbers of people going through court?
There's been a 25% increase in the prison population since 2010.
So, what's the circumstance been for the prison service then over the course of the last number of years? Has it been holding firm or has it been falling back?
In terms of its budget,
Yes.
The prison service budget over the same 4-year period has fallen from its starting point to this year by 15%. That's important to note that within that there was a significant amount, and I don't have the figure to hand, but there was a significant amount of additional funding injected into the prison service to fund an exit scheme. So the majority of the baseline reduction of 15% from years 1 to 4 is because following the exit scheme, the prison service now has a much cheaper staffing base. That explains the majority of the prison service budget reduction.
So for many of us, Chair, it's very important that people have an opportunity for justice, and those who can't afford it have that opportunity. So legal aid certainly has a role. But given that you have 30% more cases to deal with, is it still the case that you can have 2 barristers, a barrister at law and a QC representing you, and you have 1 prosecutor paid for by legal aid?
There are a number of circumstances in which it is appropriate to have 2 counsel, and we introduced changes several years ago to reduce the incidence of 2 counsel in the Crown Court. It had been running at about 50% of cases in which there were 2 counsel, and it is now down to closer to 22% where there are 2 counsel in the Crown Court. In addition, on the civil side, reforms were introduced last year to ensure that the right level of representation happens in the civil courts, so that there's an expectation at certain court tiers that it will be solicitor, at other court tiers it will be junior, and in other cases it will be senior.
It strikes me, Chair, that we're living in constrained times, and everybody's being constrained except the lawyers, who are being facilitated by the department in that respect. And certainly, you have indicated instances, but it's very evident that there still are many instances where you have the double representation, which is not required to achieve justice. And that's what your role is. Your role is to ensure that people receive justice and that their case is heard and heard adequately. But it does not always require, and certainly there are many instances where it is currently being used but not required, where we, the public, are paying legal aid, whilst on the other hand, Minister Ford was out in the middle of summer, standing shoulder to shoulder with the Chief Constable, no less, saying if we don't get this money, this is how it's going to affect policing. But then when he gets the money, he actually hands more of it off to the lawyers than he does to the police officers. And I didn't see him standing with, the fat cat lawyers. So I'm standing with the police officers. So I don't take particularly kindly that we're told we really need this money and we really need it badly because it's going to impact upon policing. Only for the majority or the largest portion of it to then be given to the lawyers when not enough has been done to reduce the burden of legal aid upon society. And it really needs to be got through to the Department of Justice that this is no longer acceptable either to the public or to the committee or indeed to the Assembly, and you really need to get your act together on this particular issue.
Well, as you know, Mr. Prince, there's a great deal of work going on to try and to reform legal aid. I'm not sure the profession would think that they're getting away scot-free, as we might say.
Well, they don't, and they're railing against it and resisting very heavily. But that doesn't mean that they're right. Everybody who's getting hurt will obviously rail against it. Trade unions rail against it. At least there are people on £5 or £6 an hour that they're fighting for. They're fighting for people who are earning over £1 million in legal aid in a year.
And there's more to do, and we have proposals to do that. We discussed the point about the allocation to police a little earlier.
Thank you, Chair.
Mr. Elliott.
Chair, thank you. Thanks for the presentation. A couple of pieces of clarification. Just in the table that we have here, I'm looking at the PSNI budget 734776 and then revised in year savings 38505. Just wondering, is that 38505 coming out of that 734 or is that 734 after?
The 734 is the opening budget, so the 38 comes out of it.
Out of that then?
The police's closing budget is the net of those two figures, yeah.
Okay. And it's the same for the others, such as the Legal Services Commission? That's
correct, yeah. The savings in pounds percentage terms are measured against the opening budget.
A briefing we got a few weeks ago, just can't find it now, it had indicated that the legal aid budget for the in-year was running behind in percentage terms of what it had been predicted to be. Now, there was an indication at that stage that there were a number of bills outstanding that would have to come in. I'm sorry, I just can't find the figures. It was in an earlier briefing some weeks ago. Can you tell us the up-to-date position of the legal aid bill against predictions?
We're currently projecting a spend of 907 million this year. I'm not quite sure.
Yeah, but up to date.
of what the actual spend is.
Up to date, yeah.
Off the top of my head, I can't. The latest figure that I don't actually have current spend figures, but at this time of the year, you're just over 50% of the way through the year. And the payments tend to be fairly even across those years or across those months. There was a bit of a downturn when the Commission reduced their weekly payment profile before the additional resource became made available. So it was down a wee bit at that stage. But I'm not familiar. I don't think I'm familiar with the particular briefing.
Chair, it'd be useful just if we could get an up-to-date figure of in-year spend at this present time and see if it is running according to projections or if there is a downturn or an upturn at this stage.
It is running according to projections. I mean, there's work which is, there are bills which have been presented which are being processed currently, and the Commission is reasonably confident in terms of its forecast about what's going to be required for the remainder of this year.
Okay. And the October monitoring round finance that went to the PSNI, I think it was 13 million, somewhere around that. Is that just given to the PSNI, or is that given for any particular project? Do they bid for a particular project, or do they just bid for PSNI?
No, the allocation is for them to use as they...
Okay. Thank you, Chair.
Okay, just finally, and there's no other members, given the 29 million that was allocated, and Mr. Frew asked what have been the consequences if that money hadn't been given by the Executive, as Permanent Secretary, did you advise the Minister in the run-up to that Executive Minister about the consequences to his department if additional funding wasn't granted?
Well, the Minister had seen all the scenarios we've been planning around how we'd absorb different levels of percentage cuts. So to that extent, the Minister was aware of that.
And did he seek a view from you as Permanent Secretary as to whether or not he should accept the 29 million in terms of how he ultimately then voted in the Executive?
Well, he didn't ask my view on that, Chair, I'm sure. Well, I know he didn't ask my view specifically. No.
But he was aware of the consequences that the department had highlighted to him, that if there wasn't additional money, here's the impact for legal aid, here's the impact for the Police Service of Northern Ireland. When he went into that Executive meeting, he was aware of all of the scenarios facing the department.
Yes, he was, yeah.
Did it surprise you that he didn't want this money, given that you had outlined to him the consequences?
Well, my understanding was the issue was less. I'm sure he was glad to get the money. I suppose there was an issue about process, but he would be better placed to answer that rather than me speculating.
Okay, I appreciate that. Well, can I thank you all very much for your time today? Much appreciated. Okay, members, unless there's any other points on the back of that, we'll move on to the next item. Okay, the next item is on the Justice Bill, and it's oral evidence from the Public Prosecution Service, so if officials want to come forward. The relevant pages for members are pages 51 to 57 of the meeting folder. Last week, members will be familiar with the way that we went through this, that we'll ask the PPS to give an outline of their submission, and then we'll ask questions going through section by section, which the clerk has provided with the paper, which would facilitate a structured way in which we can deal with that. So if members are clear, that's how we'll proceed. And let me formally welcome Baron McGrory, QC, Director of the PPS, and Kieran McQuillan, the Assistant Director of Policy and Information from the Public Prosecution Service. You're both very welcome. As normal, we'll record this by Hansard, and that'll be published in due course. So,
thank you, Mr. Chairman.
Barra, I'll hand over to you.
Thank you very much. Mr. Chairman and other members of the committee, first of all, I'd like to thank you for this opportunity afforded to the PPS to give you our view of the proposed reforms contained within the draft Justice Bill. First of all, what I'd like to do is take you through some of the proposed reforms and suggest ways in which, from the PPS perspective, those reforms might be improved. And then there were a couple of other matters I would like to touch upon, if you don't mind. One arose out of my reading of the Attorney General's submission to the committee in respect of rights of audience for employed lawyers, and the other is in respect of some of the issues raised by Mr. Poots on the issue of two consulate cases. There's something I'd like to say about that as well. But what I'll do is I'll begin with the issues within the bill. Now, you may recall that I was here 2.5 years ago when I think the second committee stage was reached or something, so it's some time ago, but I was looking through the Hansard report of that, and my views haven't changed significantly to the views that I outlined then. What I said then was that I felt that in terms of the administration of Crown Court cases, they would gratefully benefit from a suite of reforms, which, if interlinked, I felt could be very effective. Those reforms included in the review of the Public Prosecution Service the abolition of the committal stage in Crown Court cases entirely, some statutory measures around the incentivisation of early guilty pleas, case management rules, and some specific changes to legal aid, which I feel would complement the other reforms to make them more effective. Now, first of all, of those reforms which are contained within the bill, I welcome them. But in my view and in the PPS's view, they don't go far enough. And I'm going to say why now. Beginning with committals. What the bill does is it abolishes the right of a defendant to call to give evidence a complainant or a witness cited in the prosecution papers. That's to be welcomed, because the existence of that measure at the moment not only contributes to significant delay, but it adds to the stress and trauma of victims and witnesses in the criminal process. It affords to defendants two opportunities to cross-examine and examine witnesses, which in the view of the Public Prosecution Service was never really an essential component of the right to a fair trial, because that is afforded, of course, to a defendant in the principal trial process. So I welcome that reform. However, it's limited in two significant ways. It only applies to the question of cross-examining witnesses. It leaves in place the committal procedure. Now, in our view, we can't see why the committal procedure is left in place in a situation where the right to call witnesses is being abolished. While that is significant, by not abolishing committals altogether, there is remaining in place an additional process within the trial procedure, which we believe is ironically now even more unnecessary now that they've abolished the right to call witnesses, even than it was when that right existed. Since that was the principal evil, if that's not too strong a word, the principal mischief might be a better word, within the committal process, having done away with that, why not go the full hog and do away with committals altogether? Because by leaving the paper process in place, that still requires the Public Prosecution Service to prepare a set of papers for the Magistrates' Court. It requires a Magistrates' Court process, which requires the receiving of the papers, the listing of the case within the Magistrates' Court. It may then still be subject to adjournments, to other delays within the Magistrates' Court process. There is a financial tier there, of course, because the defence get paid for representing their clients within that process, albeit they're not examining witnesses. And then it also has to be referred on to the Crown Court, and that creates another delay. So we consider that by leaving in place the paper committal process, you're creating a 8 to 10 week delay in the criminal trial process that, in our view, is unnecessary. Now, of course, the other aspect of it is that the bill does contain a provision for the direct transfer of cases in very limited circumstances. Those in which the defence have indicated that they are willing to plead guilty can be directly transferred. That is welcome. And in murder and manslaughter cases, but with a schedule which will allow for the number of cases, or categories of cases, to be added to that. That of course, is welcome, but as I've said already, it's of limited value. Those are very serious cases which can now be directly transferred to the Crown Court judges, but they don't include other very serious categories such as rape or child sex abuse or other serious types of cases which, in our view, would immediately benefit from immediate transfer into the Crown Court. So, in relation to the proposed reforms of the committal procedure, it is the public prosecution view that those which are in the bill are welcome, but they could go further. In the context of the early guilty pleas, we also welcome the measure that is there, but I have to say, excuse me, I am concerned that it doesn't nearly go far enough. The Public Prosecution Service would be of the view that there needs to be a significant driver within the criminal process to concentrate the minds of defendants on the question of the benefits of pleading guilty at the earliest possible opportunity. Now, the proposed measures are that the Crown Court judge, when sentencing, will say what the sentence would have been had the person pleaded guilty or at an early stage. But there's a view that that's closing the door, bolting the door after the horse is gone, closing the door after the horse is bolted, if you know what I mean, because the damage is done at that point. And I would rather see the judicial intervention at an earlier stage, say at arraignment, where there's a requirement on the court to ascertain from the defendant, him or herself, or his lawyers, whether or not that advice has been given. Now, the bill places an onus on the solicitor to give the advice, and I have to say I have personal misgivings about that as well, because I first of all think it would be difficult to police. There's an issue of privilege between solicitor and client. So I can envision problems with the Law Society in policing that. And why is the responsibility been put on the solicitor only? In my view, if there's any responsibility, it should be on the advocate, whether it's counsel or solicitor appearing in the court, to confirm to the court that advice has been given, or indeed the court, as many judges do anyway, could say in open court, are you aware, before you make your plea at the arraignment stage, that there may be significant benefits to pleading early rather than later, if you ever intend changing your mind, and set out. But those are at an earlier stage in the process, I think, would have the potential to be more effective. There's also a legal aid issue, but I don't want to get bogged down in the minutiae of legal aid. But we have raised this with the Department of Justice officials. There are three types of fee in criminal cases. There are GP1s, GP2s, and trial fees. The GP1, if the defendant pleads guilty to all counts, is a modest, respectable and modest fee for defence lawyers. GP2 is a significantly enhanced fee and is paid if there's an entry of a not guilty plea to any offence on the indictment. And the trial fee, of course, is paid after the first day of the trial. These GP2s we see as a significant financial incentive to the entry of a not guilty plea. And I'm not saying that it's abused unprofessionally, but I think it might be better managed if the GP2 was not triggered until a later stage in the process, where it was clearer to all concerned that this was a serious not guilty plea. And we must always account, of course, for occasions when not guilty pleas become guilty pleas. It's in the broader interest of justice that there be a provision for payment of lawyers in circumstances where there's an unforeseen change in the plea. But as I say, I think that GP2 could be re-examined and perhaps triggered further down the process once the case has been listed for trial and the issues identified. So I have asked my officials to raise that with DOJ officials, and perhaps the committee would bear that in mind when those amended Crown Court rules are tabled. I think it's another factor. So in terms of the issues on the bill, those really are the ones in which I wanted to specifically comment on. There are statutory case management provisions within the bill which I welcome. The Lord Chief Justice has already introduced, by way of practice direction, significant measures which have proven to be very effective in the speeding up of Crown Court cases, and I certainly welcome that they be given a statutory footing. And certainly when it comes to the drafting of the detail of those, as I say, I would hope that those responsible for the drafting would bear in mind some of the other points I've made in terms of tying in the various points in the management process of cases with the early guilty plea provisions and legal aid provisions. And as I say, combine all of those measures together, and I think we could have a very effective and significant reform of the criminal justice process. But this bill goes a good measure of the way towards that, and I certainly commend the Department of Justice and the Minister for the measures which they have proposed. But I think there's an opportunity here which I wouldn't want to lose, given the timescale during which we've been talking about these reforms over the past 3 years. I would fear that it might be a long time before we get another opportunity, and that we should put into the bill what we can now. I mentioned 2 other points at the beginning. One is concerning statutory rights of audience. The Attorney-General has asked the committee in his submission to consider giving higher rights of audience to his employed lawyers. You may be a bit puzzled by that. The background to it is that a barrister's rights of audience is restricted once a barrister becomes an employed lawyer rather than remaining within the self-employed bar. A self-employed barrister has a right of audience by nature of the qualification right through to the High Court and even the Supreme Court. But once a self-employed lawyer takes a job and gets paid a wage, whether it be in the Attorney's Office or indeed the Public Prosecution Service, he or she loses the higher court right of audience. Now, the Attorney has flagged that up in the sense that, look, if he could permit his employed lawyers, of whom there are a limited number, to go into court, he could not only save public money, that it would be more effective for the running of his office. I have endorsed that view with the DOJ, who are carrying out a consultation at the moment, but I've also pointed out that, look, it would significantly benefit the Public Prosecution Service as well. Now, I don't mean every lawyer for the Public Prosecution Service, but one of the initiatives I have started since I came in is the creation of a higher court advocacy unit. So I have a body of lawyers within the office who take Crown Court trials for the first time ever in the history of the prosecution, and they have, those who are barristers have their right of audience restricted. So if the committee is going to give serious consideration to the Attorney's proposal, I would like you to also consider that in the context of the PPS, higher court advocates. The final point I would make would be just really to address the issues raised by Mr. Poots earlier. I was listening, Mr. Poots. PPS is concerned about the disparity in the funds available to the defence for services of counsel and that available to the Public Prosecution Service. My budget is very tightly monitored by DFP, as comes as no surprise to anybody, who monthly regulate the employment of counsel and ask questions about that. Now, the guidelines which we have approved by DFP allow us only to instruct senior counsel, that's 2 counsel, in cases of death and serious sexual offences or very serious fraud. We can only instruct senior counsel in 6% of the cases we take in the Crown Court. As you've heard, the defence have reduced their level of 2 counsel from 50 to 22%. In my view, there remains a significant disparity in terms of the equality of arms afforded to the prosecution compared to the defence. Now, currently, the structure is that defence acquire 2 counsel certificates by applying to the court. I have suggested to DOJ that they might consider, as they do in England and Wales, removing the authority to the Legal Services Commission, who could then take into account whether or not the prosecution has also instructed senior counsel. That's not to say, of course, that the defence should only get senior counsel in cases where the prosecution have it, but nevertheless it would at least give us a better chance of evening out the current disparity. So that's just something that I picked up on in your remarks, Mr. Poots. So, listen, those are my general observations on some of the bigger issues in the bill. Mr. McQuillan has his own observations to make as well, so I don't know if you want to hear from him before you talk to me about mine, or...
No, happy, because there's a few things that I wanted to pick up on anyway, so if Kieran wants to talk through them.
Thank you, Mr. Chair. Chairperson. In addition to those matters that the Director has mentioned, the main aspects of the bill from a PPS perspective are those provisions dealing with single jurisdiction, prosecutorial fines, prosecutors' summonses, and victims and witnesses, and in particular the victim and witness charters. Dealing with them in that order, we acknowledge the benefits that could flow from abolishing the present County Court and Petty Sessions District to create a single jurisdiction as the bill proposes. Criminal cases in the Magistrates' Court could be moved to suit the needs of victims and witnesses, and best use could be made of limited court resources. We do not consider, however, that business needs should take precedent over the needs of victims and witnesses when these decisions are being made. In addition, criminal cases require not just civilian witnesses, but police officers and on occasion doctors, engineers and forensic scientists. Prosecutors and defence representatives need to prepare all the cases that will appear in court on any given day. An arbitrary movement of the cases could disrupt the efficient preparation of a case and inconvenience a range of witnesses who provide important services to the public. We would hope the guidelines around how court business will be listed will ensure this does not occur. Furthermore, when the PPS was set up, it was considered a priority that it was a regional service. We have offices throughout Northern Ireland to provide a link with local communities and proximity to the regional courts. Should the introduction of a single jurisdiction reduce the number of criminal cases heard in a particular region, this could make it difficult for us to sustain our present regional structure. The introduction of prosecutorial fines allows for low-level offending to be dealt with fairly and efficiently without having to resort to court proceedings. They provide potential savings of court and prosecutor time whilst maintaining a regime of condign penalties for minor offences. Whilst there will be understandable concern that the process for administering prosecutorial fines should be carefully regulated, for that reason the legislation proposes that the Director issues guidelines to his prosecutors on how the scheme will operate. The PPS will consult on that guidance before it's introduced. The PPS is already testing the operation of prosecutorial fines, and a careful analysis of the results of our research will be carried out and will inform any draft guidance. Our own research has shown that many of the cases that would be suitable for prosecutorial fines would normally carry penalty points, road traffic offences of a low level. The bill is silent on this aspect, but were we given the power to offer penalty points in addition to a fine, we would be able to deal with these cases, and it would make the operation of the scheme all the more effective. Implementing prosecutorial fines would involve costs for those criminal justice organisations affected and needs to be cost-effective as well as fair. We appreciate that the proposal to allow prosecutors to issue summonses is a departure from the established position that the issue of summonses is a judicial function, presently carried out mainly by lay magistrates. It is important to note that a summons is only a means by which a person is required to attend court. The decision whether to prosecute an individual is already made by a prosecutor and will continue to be so. That decision is made only after careful consideration of the evidence and in accordance with our Code for Prosecutors. And any prosecution directed is, of course, open to challenge through the court process. The power to issue a summons will bring greater efficiencies, as it will no longer be necessary to attend before a lay magistrate to have summons signed and to allow them to issue. In addition, the difficulties around the service of summonses and the need to reissue those that go unserved has been a cause of delay in the criminal justice system for some time, and it is hoped that allowing prosecutors to both issue and reissue summonses will help reduce delay. The power vested in prosecutors will, however, be discharged in the same carefully considered way in which decisions as to prosecution are, and with the protection that all cases initiated by summons will be decided ultimately on by the courts. PPS welcomes the introduction of the Victims' Charter, which will be given statutory force by the bill. We have worked with the Department on the development of the Charter, and it reflects many of the practices we already have to provide an enhanced service to victims and witnesses. A particularly important development has been the establishment of our Victim and Witness Care Unit, where the PPS and PSNI staff work together along with members of victim support to provide victims and witnesses with a single point of contact for information about their case, to assess any special needs they may have, to keep them updated about developments in the case that affect them. This unit has been the product of several years' close cooperation between a number of criminal justice organisations, and means we are confident that the commitments contained in the Victims' Charter can be delivered in a way that improves how victims and witnesses experience the criminal justice system. Happy to take any questions.
Okay. Thank you very much. We'll go through section by section, and the first one was around the single jurisdiction aspect of it. I suppose my question is, for the PPS, how efficient and effective would a single jurisdiction be for the PPS and its delivery of the responsibilities that you have?
Well, as I said, Mr. Chairman, in my remarks, it will really depend on how it's operated, and there are guidelines that are proposed. Were it to be the case that cases were moved, and I understand from the Department this isn't by any means the intention, but if cases were moved in a way that would disrupt normal business, moved at short notice, or were otherwise moved in a way that made it difficult to prepare them, then that would obviously be a difficulty. But we can see advantages in a single jurisdiction. It allows, as I said, victims and witnesses needs. If perhaps victims and witnesses in a case don't reside in the area where the offence occurred, and the general principle is that cases will be heard in the area in which they occur. But if, for instance, the majority or all of the victims and witnesses were from another area, the case could be moved to that area. It may also mean, without impinging on any victims or witnesses' rights, that if there was spare capacity or there was good business reasons for moving a case to utilise scarce court resources, that could be done. So, I mean, all of those we would welcome. We don't think, from our point of view, that there's any reason why a single jurisdiction can't be advantageous. We would just caution against how it operates.
Certainly the PPS would need to reorganise how it operates to accommodate that, or what would be the implications specifically for the PPS?
Well, I think it's less to do with the single jurisdiction than the location of courthouses in juxtaposition to our offices. So at the moment the offices were located around major court centres, so I know there are discussions ongoing at the moment with Court Service about potential courthouse closures and relocations. So they certainly know our views on that, but I mean, everything's up in the air at the moment, pending the budgetary considerations. So, but certainly the PPS is structured in the way it is around the jurisdictions, but we're less concerned about the single jurisdiction in that regard than we are about the relocation of certain courthouses. But we'll worry about that when the time comes.
Courts understand the consultation on how it will be reorganised administrative divisions, and we'll obviously partake in that consultation.
Is there any other members on this section? Mr. Frey?
Would it be conceivable that if you had a court that was bunged for work and that was very, very busy, that it could be the case that a trial that was to take place in Ballymena would be moved to County Tyrone, just by the sheer fact of the level of work, and that there was spare capacity in our court? Would that be conceivable?
Well, I think there are guidelines proposed about how this will operate, and there have to be good reasons to depart from the guiding principle, which is that cases, if you like, in Ballymena will be heard that occur in Ballymena will be heard in Ballymena. There are a number of proposed good reasons, and people will be given an opportunity to make a representation. So, if parties to a particular case had objections about a case being moved, they could go to the judge and make representations, as I understand it from the department's proposals. But if it was appropriate to do so within the guidelines, it could be that cases would be moved. Though you would like to think that where they would be moved to would take into account the ability of witnesses to travel.
It could well be a balance here. Would it be the case that if you moved, you could be heard sooner? Is that right?
It may be one of the considerations. I think the efficient use of courts and the efficient discharge of court business is one of the considerations that will be taken into account.
Okay, thank you.
Mr. McCartney?
I mean, from what I'm hearing, you're not opposed to the idea of a single jurisdiction. It's how it's managed.
That's right.
Okay. How do we prevent, I mean, how do we put in place management structures that doesn't allow it to become then that there is nearly this idea there's a single jurisdiction that doesn't matter where the case takes place?
Well, the proposals that the department, when they speak to you, will be able to give you more detail on, really do allow for representations to be made by any party. So if it was, for instance, ourselves or a victim or a witness who wished to say, you're intending to move this case, but I have very good reason why you shouldn't, that should be a check on arbitrary movement. And really the concerns I was raising there were, I was cautioning about them rather than necessarily saying they would happen. I would like to think that the guiding principle that the cases will be heard in the area that they occur in will mean that the vast majority of cases will be dealt with like that. And if they're moved, it has to be for a good reason, and parties can make representations about that.
And the final say rests with someone makes a case with the judge.
It's my understanding of the guidelines that, as I say, the department will.
I mean, there's no sort of, I mean, people may have the suspicion that there are a number of court buildings now under pressure. So if you do away with the court building, then automatically you do away with the ability to have a case in a particular place. So you might see a sliding towards that, and it's how you protect yourself against that. That you don't end up where people here have at its core the protection of witnesses and victims, but through our procedures we lose court buildings and then your ability to have it closer to.
I mean, that would be a concern, and that's sort of why we've raised it. But as I say, the guidelines which the department will be able to maybe expand upon, hopefully will guard against that.
Okay. Chair, just one brief point on that. Are there any cost implications for the PPS in the single jurisdiction system?
It's more about the location of the buildings and how it affects travel and location of local staff and all that.
If it were to cause a reorganisation, then that might have an impact, but we don't know at this stage.
Okay.
Consultation to occur yet.
That's all right, Chair.
Okay. And the committals, which seems to be a big part of what you were indicating, the bill could be going much further. And indeed, my take on what you were saying is that it will still require a process, but it'll have even less meaning than what it currently has, because you're only removing one element of it, so why keep it at all?
It's not a paper process. I mean, it up to now it has afforded the defendant the right to cross-examine witnesses, and it's a right that hasn't been widely used, but when it is, it can cause considerable disruption and delay. So we have examples of a number of cases which have been in the magistrates' court process for over a year, and some quite recent controversial cases, as you know, Mr. Chairman. This is a feature of it. So, but the removal of the right of the defendant to ask the questions is a significant development. Let's not take away from that development. But what the department has proposed is leaving in place the paper process. But I'm puzzled as to why, when they've removed the right to cross-examine witnesses. So there will now be no oral evidence, no preliminary investigation, but existing, but the preliminary inquiry will, which allows the defence to seek disclosure, to make applications for abusive process, to make an application to the magistrate, or the district judge, sorry, to not to return the case. It requires the Public Prosecution Service to staff a lawyer to go through that process. It takes time, and then there's another process in sending it to the Crown Court where it all begins all over again, where applications for abusive process can be renewed, applications for disclosure renewed, where an application for a no bill, for example, can be made. So the defendants effectively get two bites of the cherry. Now, I'm aware of the argument, which will come from the defence side, that, well, look, this is an essential part of the trial process. I agree, but I don't know of any construction of human rights jurisprudence which allows you to have it twice. It's a luxury. It's an historical anomaly, in my view, which no longer exists in all, the GB jurisdictions, and it's expensive. It's expensive for the public purse, not only in terms of the extra cost to legal aid, but it's expensive in terms of the burden it puts in the public prosecution service. And I can see no value in keeping it. So that's my view.
And what about the argument, though, that it actually helps produce earlier guilty pleas and withdrawal of charges?
Show me the evidence. Show me the evidence.
You're not aware, you can't point to evidence that would
No, but I mean, funnily enough, but within the bill, though, is a helpful provision where if a defendant wants to plead guilty, indicate a guilty plea, during that process, they will skip it. So they will automatically go to the Crown Court. That's a very helpful provision here. But why not have that with everybody? So I mean, I haven't seen any empirical evidence which would suggest that people are wishing to plead guilty at the magistrate's court stage of a case.
Okay. Mr. McCartney?
We're on the abolition, we just moved slightly forward, but I mean, what was the original intention of the committal proceedings?
It's an historical procedure which probably, I mean, dates back to the days of the grand jury, whenever there was a very intricate process which allowed for examination of witnesses at various stages in the process, allowed for the holding of a grand jury to decide whether there was a true bill and all of that. But that was done away with in the late 1960s because it was seen as a third tier and very cumbersome tier. The magistrates' court stage and the committal procedure was an historical procedure which has remained in place in this jurisdiction. It was done away with in England and Wales quite a few years ago because it was seen as a cumbersome and unnecessary additional element to the process. I mean, it harks back to the days whenever there was a view that all of these procedures were necessary to afford people their rights, but they're expensive and they're costly in terms of victims and witnesses' experience of the justice system as well. So I think in the modern world where we are now in 2014, given the victims and witnesses issues that are now coming into focus and the issues of cost, we have to ask ourselves, is this a necessary part of the process? And I can see no strong argument to keep it. Others may argue differently, but from a prosecutorial point of view, we can give people a fair trial without it. The courts are the people who give people a fair trial. Let me make that clear. I'm not claiming that that's our responsibility necessarily, but we play a significant part in that.
In terms, you see, a lot of what we're doing here today, you know, and I mean, a lot of what we've done in this committee around this particular type of issue, the backdrop has always been, you know, the high cost of the criminal justice system in terms of legal aid and all that contributes to it. And many of the measures within this, one of the strong arguments promoted by the department is it saves money. So if you look at all these different layers, you know, and we'll get into it later on about early guilty pleas and doing away with committal. It's nearly streamlining the justice system, but nearly the imperative to do it is to save money rather than to preserve the quality of justice. So how do we protect ourselves against that? Because everything that you're saying, early guilty pleas, if you do it early, it saves money. You know, missing from it seems to be where not a person gets no fairness. You know, and we get into the early guilty pleas because many of the people who present themselves in front of courts are very vulnerable people. You know, we've seen in terms of our prison statistics, their literacy and numeracy skills are very, very low. So if they're put in a situation where someone says to them, if you don't plead guilty, you know, you're going to get a heavier sentence. You know, if you're vulnerable and, you know, you haven't got the full ability of a thinking person, you can be bamboozled or you know, practically coerced to be quite in a gentle way, but coerce them to make a decision which isn't in the best interest of yourself or the justice system overall.
I know, I appreciate that, but like everything else is getting the balance right.
Yeah.
And I think if you build in sufficient safeguards to the system, you will balance out those concerns. I mean, I would never want to go, for example, to the American system of plea bargaining, where the prosecution will come along and say, well, you know, you'll get 20 years if you plead not guilty. We can give you a deal for 10. You know, that's not what we're talking about here. What we're talking are very measured reforms, which would simply put in place procedures which would remind defendants that if they're going to change their mind down the line and plead guilty, then they would be better off doing it sooner rather than later. And the statistics show that, I think the last statistics we had were 2012, something like 28% of defendants who pleaded not guilty changed their plea before the actual trial. That's a very significant number. And if they pleaded guilty before their trial, well, then they knew they were guilty when they pleaded not guilty. So you know, those are the people you're talking to. But of course, you must have in place provisions for legal advice at the point at which they've been asked to make their plea, and that those measures which remind them of the consequences of a subsequent not guilty plea, where they're pleading, or subsequent guilty plea where they've pleaded not guilty, need to be done in a measured way. So that's why we have certainly taken the view that, well, look, those proposals in the bill which require the solicitor to do it, are on balance just won't be enough. So you could maybe require the court to mention it, or require the court to ask the advocate whether or not the statutory advice has been given. And I'm reminded actually that the Law Society who are coming behind me, in their written submission, are suggesting that it's the prosecution's responsibility to do that. But with respect to the Law Society, their members would be screaming blue murder if the prosecution tried to approach any of their clients to suggest to them that they should plead guilty early. So I don't know how that one's going to work in practice. But in our view, it should be the defendant's lawyer's responsibility to give the advice, if not in conjunction with the court. I mean, for example, in terms of the decision on the part of the defendant whether or not to give evidence, there are provisions which trigger the advice and the potential taking of adverse inferences at a certain stage in the process, which are governed by regulation. So I see no reason why we couldn't do it in a similar way with the guilty pleas. Bearing in mind your concerns, Mr. McCarthy.
Okay. I'll return to the guilty plea. Sorry for straining that, Chair, but you see, again, when you're talking about the committals, it's this sort of, you know, application for disclosure at committal and an application of disclosure at trial. When do we get this situation, you know, because it would strike me that a good prosecutor, you know, or a good prosecuting system, if there was evidence or material became available to prove a person's innocence or assist the defendant's case, that a prosecution service would hand it over immediately to the defence. Now, the suspicion has always been that doesn't happen. You know, maybe increasingly it's changing. So, but where do we get this situation that no applications for disclosure perhaps could become something of the past?
But you see, if you abolish the committals, it'll solve a lot of the problems, because at the moment the structure on disclosure is that primary disclosure is given at the committal stage. The secondary disclosure isn't triggered until after the defence statement comes in, but that's after committal. That's between the committal and the arraignment. So then the issues are in play and the prosecution reviews the issue of disclosure. So I actually think it would work in the defendant's favour if you remove the committal process altogether and then you look at disclosure from the point of view of delivery of the papers and bring forward the point at which the defence says what their issues are. So, I mean, the law is very clear on disclosure. Absolutely, the prosecution has a duty to disclose anything which is of assistance to the defence and detrimental to the prosecution, and that is constantly reviewed. But the trigger for the second review is whenever the defence declares its hand, so to speak, in terms of the issues. So, if that is earlier in the process, then we can give the disclosure earlier. So, I actually think they're there are ways in which an abolition of committals could benefit defendants as well as prosecutors.
And as a prosecutors as well, we are under a continuing duty to review the prosecution, and if we were to be provided with a piece of evidence in whatever way that no longer meant the case no longer met the evidential test, then we wouldn't be prosecuting the case. It wouldn't be, our duty is to apply the test for prosecution, and we do that throughout a case.
Okay, thank you.
Mr. Poots.
Thank you, Mr. Chair. I take it, with your reference to the committal, Mr. McGrory, that there's things that you can give absolute clarity on, that in terms of equality, that will not be diminished. In terms of efficiency, that will be improved, and in terms of effectiveness, it will be improved.
Well, I realise that in advocating the abolition of committals, I'm putting pressure on my own organisation, because there's an argument that by going through the committal process, when we issue papers and send them over to the Magistrates' Court and issue them to the defence, we buy time. And you abolish that, we're going to be under pressure to be ready to go to trial potentially earlier. So I'm very well aware of that. And that may be the reason, partly, for the incremental approach taken by the Justice Committee. Because the Justice Department may take the view that, well, if we abolish it, the system wouldn't be able to cope with the pressure. I think we would just have to get ready for that. But I mean, in terms of your question, Mr. Poots, I would have to say that would put us under pressure. But I think we'd have to tool up and be ready to respond.
But none of those tests that I put to you is my view of them, as you have elucidated today, correct or wrong?
Sorry, I think it's my fault. I haven't listened to your question properly. Sorry.
Okay, I said in terms of equality,
yes,
it wouldn't be diminished. In terms of efficiency, that would be improved, and its effectiveness would.
I think it would be, yes.
Yeah. Okay.
Yeah. Sorry, I misinterpreted what you were saying.
Sorry. Thank you,
Mr. Lynch.
Yeah, thanks, Chair. In terms of delays, how much do you think it would speed up justice? How important would it be in the process of speeding up justice?
As I say, the committal process adds about 8 to 10 weeks to the process. Take it out of the picture, and that will put us under pressure to be ready to go to trial quicker. I think we can do that. If the committals are abolished, we would have to reorganise completely, but as would a lot of other people. In terms of the average time it takes to get a case to court, there's at least an 8 to 10 week saving time, in our view.
Okay. Other members on that point? Okay, then prosecutorial fines. Is there any member who wants to raise?
Just in relation to, I don't think we've seen this the last time, Kieran made the point that if there's points involved, at present, that wouldn't be covered.
At present, the bill is silent on the issue of points. It doesn't mention it now. It may be that points could be available to a prosecutor when they're issuing fine, either through the bill itself or through a different arrangement that may, fall to be discussed with the department. But at the minute, it's not. The power isn't contained in the bill, so the bill is silent on it.
And as the bill's written, if it went through, does that reduce the number, or does it just leave it unsaid, so to speak?
Our view is that a large number of the sort of cases, the low-level cases, which is really what we're talking about for prosecutorial fines, a large number of those would be low-end road traffic offences, and they carry, a number of them carry, for instance, driving without due care and attention carries mandatory 3 points. If we didn't have the power to impose penalty points, then we couldn't offer a fine. Well, we could offer a fine, but we couldn't offer penalty points with it if we didn't have that power, and that would preclude it from being one of the offences we could use. So yes, it would reduce the numbers of cases where we could use prosecutorial fines.
And has the department give you an indication, or is this just now the first time it's been raised?
No, I think to be fair to the department, our position on this has probably evolved over time. We have raised it with the department in more recent times. It's not a straightforward matter, by no means. And it is something that we have raised with the department in the last 12 months. But as I say, I think to be fair to the department, it's something that maybe we've taken a new view on more recently, having looked at it and having carried out some of the research ourselves by looking at the sort of cases that we might look to put or offer prosecutorial fines on. We've thought this might be useful. This might be a useful addition.
Okay, thank you.
So just to be, for my benefit, to be clear on that, this is for an offence where you're going to get your 3 penalty points, but you'd need to go to court to get them. The PPS can have the power to say, well, take your 3 penalty points, and from us, you don't need to go to court to do it.
That's
in essence is
yes. That's it in essence. In addition to a fine, and we would obviously seek to put the fine at a level that would be appropriate to the offence and reflect the sort of practice that the courts would presently do. That's the proposal.
So could you have the scenario where you're able to dispose of the fine element of a road traffic incident, but you'd still need to go to court to get your penalty points?
I don't believe that could happen under the bill as currently drafted. I think the proposal to you offer a prosecutorial fine, if that's paid, that's the end of the matter. So I don't think there can be a twin track, but prosecution plus fine.
I'm trying to think of the type of cases that you need to go to court to get penalty. I got penalty points and I didn't need to go to court for them.
There's a range of cases that the police dispose of.
Long before I was chair.
Major disclosure.
Could you clarify that, Chair? Could you clarify?
There could be a resignation mark.
Yes.
They're nice.
Not going on that subject.
They're nice spent. I've served my time, so surely I'm allowed to continue.
I think I'll find you'll not have a committee if you went down that road.
Or witnesses. I think that there are a range of offences that the police can issue fixed penalty notices without you having to go to court, and it would be the sort of thing we're talking about, where the no seat belt, the low-level speeding cases. Then there are a range of cases, sometimes the same cases, if somebody's already had fixed penalty notice, where the police choose not to impose the on-the-spot fine with setting your licence off and you get the points on them, and they send them to us for prosecution. Now, at the minute, we only have the option of prosecuting that case through the courts. We have some non-court diversions, but generally where points are involved, because points should be imposed for those offences where they're mandatory, our only option is to prosecute that through the court. So there are a large number of cases that go to court for relatively minor road traffic offences. Of course, if somebody denies the offence, then they are entitled to go to court to defend themselves and to be acquitted if that's what the court decides. But there are other cases that come into us at a relatively low level, and those are the sort of cases that we're sort of looking at, the cases that really we at the minute send to the courts, that the courts impose a fine, relatively modest fine, and the mandatory points. And we would envisage those sort of cases could be taken out of the court, saving court time, saving prosecutor time, and allowing everybody to dispose of the case quickly. And those are what we have in mind.
Okay, well, I pleaded guilty early and avoided a court case. So.
Exactly.
Sorry, Mr. Free.
Yeah, just on that, how many cases, we mustn't be talking about many cases, because if you're not going to take your penalty points off the police officer, in effect, and their hand is forced to send it to the PPS, the offender isn't going to then say, oh, well, okay, you give me them then?
No, sorry. The guidance that I mentioned earlier that we will issue will really try to target those cases where we believe that they will be accepted. So if somebody has denied the offence, we don't believe that there would be much reason really to offer them penalty points if they've already been offered a fixed penalty notice by police and refused it. There are a class of cases which they're not offered a fixed penalty. The police send to us where the person hasn't turned down a fixed penalty notice or isn't denying the case. They just have to come to us because of maybe previous disposals, maybe, for instance, the police don't believe that their fixed penalty notice, which is, I believe, £80, and 3 points for certain offences. They maybe feel that the case is too serious, perhaps the speed was too high in a particular case, and they will send it to us.
Yes.
And those aren't cases where we can necessarily say the individual would refuse the offer of a prosecutorial fine.
There is a groundswell of opinion, certainly I'm aware of it, by people coming into my office to say that sentencing around this sort of low-level crime can be very lenient. How would you, as a PPS, guard yourself against that accusation if you were administering points?
Well, if we were administering points, or indeed fines without points, we'd be very conscious of the fact that we are, if you like, not imposing a sentence, because only courts can do that, but certainly imposing a penalty for wrongdoing. The guidance that the Director would issue and that we would consult on would assist prosecutors and when they're assessing what to do with any case, whether it's a case, simple prosecutorial fine case, or if points were made available, and it would attempt to achieve consistency amongst prosecutors who would pay heed to this guidance.
So that guidance will basically fix it for you?
Well,
or will you be able to?
It's one of the things that we'll consider when we're drafting the guidance, whether there should be perhaps bands of fines, whether there should be fixed fines, whether there should be, how flexible the regime would be. A magistrate who hears a case has quite a wide discretion.
Yes.
And we would seek to achieve consistency, to give guidance to our prosecutors. We would one of the things we would consult on is how much flexibility should there be within the fine scheme, and it may be that, as I say, there are bans or there are particular amounts and particular considerations.
You say in your paper here, to this end we feel that for fines to be effective, prosecutors should, in addition to the provisions to offer a fine and in appropriate cases compensation to an offender, have the power to offer penalty points to an offender in those cases where there's mandatory penalty points. What does it mean, appropriate cases compensation to an offender?
The bill at the moment provides that in cases of criminal damage, there is provision to make an offer of not only a fine but a compensation order within the bill, and it's restricted to those cases where there has been damage. So very often, if there's an offence of criminal damage, a window will be broken, and that window will cost £100 to fix, or however much it costs. And when a court deals with that case, as well as imposing a penalty on the person who is guilty of the offence, they will also make a compensation order or a restitution order, it's often called in court, for the amount of damage. And the bill as it stands now allows that with the prosecutorial fine for there to be a compensation order in those cases.
So it allows that at the minute?
It does.
Right, okay, thank you.
Mr. Poots?
Yeah, in terms of penalty points for motoring offences, why are they always done in bands of threes? You know, why can you not get 2 points, 4 points, 5 points? They always appear to be in threes, so you could, you could be doing 34 in the 30 and get 3 penalty points. You could be doing 44 in the 30 and still get 3 penalty points. If you do 46, then you go up to 6.
There are certain offences that carry, they don't carry a band of points, they just carry points. But in answer to your question, I don't know why they tend to be awarded in 3 off the top of my head. I couldn't.
Elsewhere, it's done differently.
I don't know. Personally, if you had, I would be speculating, but I don't think that it has to be in 3s. But it's certainly my experience is in practice that it does tend to go up in 3s. But I couldn't answer the reason why that is.
Mm-hmm. So, if someone who had 3 offences over 2.5 years and was caught doing 35, there could be the discretion to give them 2 points.
No, there's a minimum of 3 points.
Yes, I know there's a minimum of 3 points, but there could be that discretion brought in if you really wanted to.
Well, if points were made available to us, it would have to be on the same basis that they're available to the court. I don't think we would seek to have it on any other basis.
Mm-hmm. I'm just talking about the system in general. Aside from that, I had a particular interest in a previous role I've had in actually having fixed penalty points, or not fixed penalty fines brought in for people who behaved in particularly bad ways. And I'm thinking of key workers here, whether it be people who abuse fire service workers, ambulance drivers, nursing staff in our hospitals, and indeed in police. And I'm talking about the more moderate cases. Because I think that it is an opportunity to nip some of this stuff in the bud before it does get out of hand. Where if someone does come into a particular place, an emergency department or indeed an emergency vehicle, and kick off, that they're told immediately that there is a fining system in place and that will be instituted if they don't settle themselves down. Now, if their behaviour goes to another stage, obviously it should be prosecuted. But I think that a lot of people are not prosecuted because people don't want to go through the prosecution process, but they should be punished because of their behaviour, and there should be a zero tolerance to this. Would there be an opportunity within the Justice Bill to do something on that particular front, in your view?
Well, the provisions, sorry.
Oh, no, you go first.
The provisions as they stand would allow, depending on what the behaviour was, if the behaviour was
Foul language.
If it was maybe perhaps defined as disorderly behaviour, which it could be if the hospital, if it was in a public place within the hospital, then that's the sort of case that we would anticipate using prosecutorial fines in. I should say that we do take the view that offences, even low-end offences that involve public service workers, that is an aggravating factor as far as we're concerned. And we may take the view, even though we could impose a prosecutorial fine,
yes,
that in fact we would seek to prosecute that through the court, because I know that the courts also take a very serious view of offences involving public service workers within the health service and otherwise.
Yeah, I'm looking for whether it's possible as opposed to an opinion.
It
is possible.
I think we could deal with it in the guidelines, and I think it would be a factor, an aggravating factor, which prosecutors could take into account in determining whether or not that was an appropriate disposal.
Yes.
In terms of the circumstances, I agree, Mr. Poots. We could certainly look at that.
And for us to do something on that, we don't need to do anything in the legislation. It can flow from the legislation.
It provides for that.
Okay.
Yeah.
Okay.
Anyone on the victims and witnesses aspect? No, only let me welcome the welcome that the PPS have made of that and the ongoing work of the Victims Witness Care Unit. Maybe, Barra, when you're here, in terms of the budget pressures that you're facing, are there any implications for the Victims and Witness Care Unit?
Not this year. We intend to protect it as much as we can. It's jointly staffed between ourselves and the police, as you know. So we don't share the whole burden, although it's both locations are on PPS premises. So as things stand at the moment, there aren't any specific pressures on it. But that's not to say that in the forthcoming discussions on the allocation of the funds to the various departments, of which we are one, it might not come under pressure, let's put it that way, but we're in discussions with DFP, as is every other department at the moment.
Okay. Going on it then. And you had no comment on the criminal records aspect. Is there any member who wanted to ask anything on the criminal records aspect? No. On the live links, and PPS is welcoming. Is there anyone that wants to ask on it? Mr. McCartney?
We heard last week from a number of bodies, and there was some concern over particularly children in terms of live links. I'm just wondering if you have any opinion about the use of live links for children.
The applications for live links, or the guardians of those applications and the rights of people who are subject to them, will be the courts, and the courts have a particular regard for the rights of young people. And, you know, as do we when we're both dealing with young witnesses and young defendants. So
probably to their benefit, Mr. McCartney, really. Yeah. You know, so it's to be welcomed in that regard.
One of the points made was sometimes that, you know, someone who's distant from something maybe just doesn't fully grasp what's happening. Whereas at least we're, and I accept what you're saying, some settings, obviously, you know, cross-examination of a young witness is better done, you know, by a live link, but in some cases where they're not in the room, they may not get the gravity of what's happening around them.
Yeah, and not only that, but as a prosecutor, you prefer your witness to be live. You'd want the jury to see and hear the witness firsthand, but again, that's a balancing exercise which has to be engaged in by the court and the lawyers involved as to the best evidence, which is really the principle upon which these decisions are made. So it's all balanced out, but I think it's a useful provision.
Okay. And just one final point, in terms of, I think it was the Law Society last week made the point, or not the Law Society, the Law Centre, or the Human Rights people, maybe partly, just my apologies. In terms of the first hearing, the first remand being by live link, they were saying maybe there should be a protection. That should only happen if a person has already had legal advice. It shouldn't happen if they've had any legal contact for a first hearing. Have you any opinion on that?
It's in our interest that all defendants get legal advice at every stage, so we've no difficulty with that.
Okay, thank you.
It's the same point.
It's the same point.
All right, sure.
Okay, I'll go ahead.
Okay, Violent Offences Preventions Order. Is there any questions members wanted to raise on that? Okay, the miscellaneous element, the early guilty pleas. Mr. McCartney.
Well, I mean, I think I've made that. I mean, and I noted in your presentation that you said reservations about who should do this and when.
Yes.
And I mean, and so we'll look at this as we get more witnesses in terms of face the bill. Whereas, in terms of interest of justice, people should do the right thing at the right time. But I would have a concern because, it's even someone who might not know the difference we say, like say actual bodily harm and grievous bodily harm, could plead guilty for grievous bodily harm, where if it was contested and went to trial, it could be reduced to actual bodily harm, then a lesser sentence. So someone could be, unwisely put in a position to make a decision at the wrong time. And it's what protections we put in place to ensure that doesn't happen.
Legal advice. I mean, if the defendant has his legal advisor, which he really must have, available to him or her at the point at which the decision on the plea is being made, there should be no difficulty, in my view, in terms of pressure, about a gentle indication that if you're going to plead guilty at some point, it's better to do it now. But it shouldn't be before the point in the proceedings at which all the material is available. So I have no difficulty with that. I mean, but by the arraignment, it should be available. But those safeguards can be put in place. But I just worry that certainly at the moment, while all practicing criminal lawyers know that the defendant will benefit from an early plea, I just would be concerned that there is no real focus on that fact. There's no driver, there's no trigger to focus the mind on that fact available in the case management or procedural structures, and that what really we're trying to do here is to put something into the system that will address a defendant's mind to the inescapable fact of the law that if they're going to plead guilty to this offence, they will do better in terms of sentence than they will do by leaving it to a later stage in the process. As I say, there are just too many reversals of pleas on the statistics to ignore the fact that we could do something to avoid these changes of plea later in the system. So, and like everything else, it has to be balanced. It has to be weighed against the rights of the individual. And you certainly wouldn't want to be doing anything that would put anybody under undue pressure. I couldn't agree more. But I think this measure which is proposed just doesn't quite get there, in my view.
And in terms of getting there, because you touch on it about the statutory provision for additional discount.
Yes, well, at the moment there is no specific statutory provision requiring a court to give discount for an early guilty plea.
Right. Okay.
Certainly, there's a statutory provision which requires the court to take into account the stage at which the plea is given. But maybe consideration could be given to, and I don't think I mentioned this in my opening remarks, an actual statutory discount, which the court must give. Again, there may be those who would argue that that's getting closer to the pressure on the defendant than they would like, so I'm not necessarily advocating that. What we were advocating was rather having points in the process that would require the defendant and his or her advisors to address the fact that if I plead not guilty now and then change my plea to the same offence later, I'm at serious risk of a longer sentence. And the provision of requiring the solicitor to give the advice, I think, is unlikely to be effective. Most solicitors ought to be given that advice anyway. It would be difficult to police, and why not bring it up front to the court process? And as I say, it should be the advocate rather than the solicitor, because it rather lets counsel off the hook by putting the pressure on the solicitor and not the advocate at the point of the plea. But I don't know why it was made on the solicitors. The responsibility was put on the solicitor's shoulder, but I certainly don't think it should be for the prosecution to do.
And in reference to our written submission, where we talk about the success that there's been in England and Wales about this is really schemes in England and Wales where the very early guilty plea has allowed cases to go to the Crown Court very quickly, that this bill provides for, where there's an indication of early guilty plea as well. And that has proved great success in England as well, where there's, if you like, additional for even before the arraignment, where there's early guilty pleas indicated, as this bill provides for. That should be recognised.
And just for me to clarify, Barry, you had said that, is it at the point of arraignment, 28% of defendants that plead not guilty then plead guilty?
Subsequently, that was in the 2012 statistics in the consultation document.
And is that, at what point do those 28% change? Is that before the trial commences?
Could be right up to the day before the trial. But the problem for the prosecution is that once there's a not guilty plea entered, we have to be ready to run that case. So that then triggers a very considerable amount of preparation that could have been avoided had the plea been entered at the earliest opportunity. So that's a significant volume of cases.
So that 20% is all up to the point before the trial starts. It's not when the trial starts.
Can't tell you whether some of them were a week later and well before the trial, or right up to the door of the court. Okay. I'm afraid, but obviously the later it is, the more work is done by the Public Prosecution Service. But certainly the amount of paperwork and preparatory work that is triggered by the entry of a not guilty plea is very, very considerable. Counsel have to be instructed. They start preparing the case. We have to prepare papers. We have to go through a disclosure exercise. All of those things are done in cases that maybe could be avoided if there was an early guilty plea. So I don't think we're doing as much as they're doing in other jurisdictions on this point.
Just in terms of the statistics, but could there be a breakdown maybe for us to see it? Because is there a scenario where people maybe have, say, it's a more serious charge and then they plead guilty for a lesser charge? And that's where that whole...
Yes. We will try and provide that. Can we do that? Yeah, but I think the statistic I've given you is the same charge.
Same charge?
Yeah.
Okay.
I think so.
And it should
but
be...
I check that, Mr. McCartney.
You're saying it's around that arraignment point that there needs to be a much greater onus on the advocate, on behalf of the defendant, to be engaging in this early guilty plea. And then I wanted just to tease out where the responsibility on the judge to ask the advocate, have you spoke to your defendant about this, or can it be a double lock where it's both the advocate and the judge reminding the defendant?
I would prefer the double lock, and it's just that the judge asks the advocate, have you given the statutory advice? That's all he need do. That will concentrate the mind of the advocate, and it's a statutory requirement. Now, a lot of judges do this anyway. At arraignment, will say, in fact, there's one judge who's notices up all over his court that are inescapably obvious that if you plead guilty now, it would be beneficial in the long run. So, but other judges don't do it, and I'm not in any way being critical of judges. I'm just saying that if we put in place the requirements, then there's consistency across the board. So, it's, in our view, it would help.
Chair, yeah, I had originally been going to ask Mr McGrory about the Law Society's assessment that he thought it should be the Public Prosecution Service to advise the clients of that. But anyway, you've answered that. The early guilty plea and obviously the discount option. How much views are taken of the victims and all of that, I wonder, or how much account do you think should be taken of the victims' views? Because quite often I think that the victims are set aside in that process, because victims have come to me and said, look, I didn't have the opportunity to have my day in court, actually explaining what did happen.
Well, there are provisions in place for victim impact reports now to be made available to courts whenever the sentencing process comes. Difficult to see how the victim could be engaged in respect of the decision to plead, which is really the defendant's decision. So there are other issues around representation of victims.
But I'm thinking around the discount, the level of discount that's available then.
Well, if a defendant decides to plead guilty at the earliest opportunity, having been reminded of all of this by the lawyer and the court and so forth, then obviously the judge will have to weigh in the balance the level of discount given by that early plea and whether or not that early plea was really forced by overwhelming evidence or otherwise against the interests of the victim in terms of the sentencing principles. So I think there's enough there to balance that out, Mr. Elliott.
There's no more safeguards can be.
I don't think so. Not in my view that I can think of.
One of the reasons that a discount is given for an early guilty plea is that it takes from the victim the concern that they may have to give evidence in a case, and that's been recognised as, and victims have said that that's one of the things about the criminal justice process that they find difficult, that the prospect of giving evidence. So to take away that, if you like, concern.
Although there are some victims that have come and said, hey, I haven't got my day in court. I would have liked to have stood there in front of that person who caused damage to me and my family.
And in addition to victim impact reports, we have now victim personal statements as well since the start of the year.
I would say though, if you were to canvass most victims, the relief of not having to
no, I totally accept
evidence
that.
would outweigh the desire to face the other person in court. But certainly the prosecution frequently do relay to the court the level of relief to the victim, and in particular types of case, most notably probably sex abuse cases, but it applies to all sorts of cases. The degree of relief can be much higher.
So.
Sorry, as a point has occurred to me that I forgot to mention earlier on the committal point. Do you mind if I mention it, Mr. Chairman?
Well, do you want to come back? I'll finish this section and then I'll come back to committal.
Yes,
if that's okay.
I'm just going to go back one more also to the prevention orders, Chair. That's okay. Do you have a view on the debate around under 18, over 18, with regards to the allocation of violent offences prevention orders?
I don't think we do. No, it's
on it.
It's really a matter for the makers, I think.
Okay. And then with regards to the domestic violent offences prevention orders, the rest of the UK, do you see the need for a specific prevention order for domestic violence?
One of the things that we saw, and I tried to reflect this in the document, is that violent offences prevention orders would seem to be suitable in certain domestic violence cases, if they met the qualifications for those, because they might provide that extra protection for a vulnerable victim that so often is the case in domestic violence cases. So whilst we wouldn't have a view on whether it should be, the English scheme should be expanded, it was one of the reasons that we welcome their introduction as a further means of protection for victims.
Okay, Chair.
Chair, first of all, apologies for I had to attend talks down at Stormont House, but if I could ask the Director in relation to early guilty pleas, is that permissible at this stage?
Yeah, that's the section we're finishing.
Yes, okay. Clause, I believe, clause 77, 78. The Law Society, in I don't know if anybody else has asked this question. Maybe they have.
We may have dealt with this.
Yeah, I'm sorry if I repeat
No,
this.
no, not at all, Mr. O'Neill.
The Law Society have suggested that the bill be amended to place a duty on the PPS to notify the client of the discount scheme for earlier guilty pleas as part of their duties in relation to summonses and charging procedures and disclosure. Have you any view on that?
Yes.
We all know it. We can.
You know,
I'm
sorry.
We know it, we're not telling you.
I suppose, to be fair, we didn't really tease out exactly why, because I think, well, I'm pretty accepting of what
You're kinder to me than the vice chair.
Yeah. No, I don't think it would make a dot of difference if the prosecution includes in the summons or charge papers or committal papers a clause which reminds the defendant of the potential benefits of pleading guilty early. I mean, it really is the responsibility. And I mean, we couldn't do it in any other way, because if we were to try and approach them, we'd be held accountable for interfering with the Law Society's clients. But I think it's really a function for their own lawyers, advocates, I think, as well as solicitors. And the court could play a role in this, I've suggested, as well.
Of course, they're saying, look, it's not really appropriate for us to be doing that.
Well, the legislation puts the responsibility solely on the shoulders of the solicitor.
Yes.
I agree with the Law Society isn't quite right in a number of respects. So I think the burden should be shared between solicitor, counsel and the court, frankly.
Yes.
But I don't really think it's a matter for the...
Or should it just simply be an obligation placed on the court?
I've mooted that.
Sorry, Chair.
Okay, well, if we want to wrap up, you want to mention...
There was one point about it's only a minor point, but on the committal issue, double-edged point this really, but one of the benefits of automatic or straight referrals to the Crown Court in all indictable cases is that the management at the early stages of the case will then be carried out by the court of trial rather than the lower tiered court. Now that will have advantages and disadvantages. Obviously, in the current state of affairs, a lot of time is spent at the magistrates' court case waiting for materials to come from the police and for the prosecution to make the decision to prosecute in cases which have been immediately charged. And there might be a view coming from certain quarters that, well, by elevating the management of the cases at that stage to the higher tier, you're putting a burden on the Crown Court, which it would rather not have. I think the benefits, though, would outweigh the disadvantages, because that would concentrate the minds of all of those preparing the papers much more stringently if the court of trial is the one, is the court putting the pressure in terms of progress. I think that in the longer run, while there would be teething problems, would be beneficial. But that's just a minor point that I'd neglected to mention.
Finally, you had mentioned the rights of audience issue.
Yes.
And the current only self-employed have that, and once
Yes.
you become an employee,
Yes.
you lose that right to
Yes.
audience. Are there any clear reasons why that has been the case? What's the historical reason for that change once you become employed?
I'll articulate as best I can my understanding of the bar's reasoning. Mr. McGuinness might be in a better position if he agrees with it, which is that the self-employed bar carries a degree of independence over and above that of those barristers who are employed, whether they be employed by Public Prosecution Service or the Attorney General or some other body. Now, I would draw a distinction between barristers who work for, say, a company as legal advisor to, say, Nordbrook or something, or an insurance company, and lawyers who are in daily practice in the courts, like those who work for the PPS. And the Attorney General would like to include his lawyers as well in that. So I think a distinction can be drawn and that, you know, as we progress, more and more lawyers, more and more barristers may seek to become employed barristers. You know, the PPS is a classic example. I mean, we have a mixed economy between employed lawyers going to court and members of the bar, whom we instruct through the panel system. Now, I would like to increase the level of employed lawyers that we send to court, but I'm inhibited from doing that because they don't have as good a right of audience. And there's a bit of, in my view, there's a bit of
Protection.
a bit of a turf war going on here, a bit of protection. I don't want to use it's anti-competitive, but the reality is that that's what's happening. The less we're able to send our lawyers into the higher courts, the more we have to use the bar. And I mean, I've no axe to grind with the bar. Other than that, I think it's an uneven playing field when they self-regulate in a way that restricts the right of audience of the lawyers who are in my employment. I just
So
think
those that are employed by the PPS or indeed by the Attorney General's office, but those that are employed could be more utilised.
Absolutely.
Are they currently then not being fully utilised in a way that...
Absolutely. I mean, I have 160 lawyers, many of whom are barristers. They have a right of audience up to the Crown Court, but they cannot go into the High Court and Court of Appeal. So that's an inhibiting factor. Now, I have now created an in-house advocacy tier at the higher level, so they do go into the Crown Court, but they're not allowed to do their own appeals because of the bar regulations, and that then affects the way in which I can use them.
Okay.
You know, the bar also recently moved to ensure that those lawyers don't wear the barrister robing and so forth as well in any court, which again was setting out a message discriminating against employed lawyers, and I'm very disappointed by that. But so I would certainly join with the attorney in asking that consideration be given to a statutory intervention there.
Okay. Can I thank you both very much for coming?
Thank you very
to the
much.
committee? Much appreciated. Okay, members, will move on to the next item. And that's representatives from the Law Society to hear oral evidence on the Justice Bill. So if they want to step forward. Pages 59 to 69 of the meeting folder has the relevant papers. And joining us today is Arlene Elliott, the Junior Vice President, Alan Hunter, the Chief Executive, and Peter O'Brien, the Deputy Chief Executive, all from the Law Society. And you're all very welcome to the committee. And as normal, we'll record this by Hansard, and then a transcript will be published in due course. So we'll follow the same format as before. I'll open it up to yourselves to briefly take us through your submission, and then we'll ask questions based on the relevant sections that you've made comments on. So if members are clear, then I'll hand over, Arlene, I think, to you at this stage.
Thank you very much, Chairman. I appreciate the committee have had a very long afternoon, so I would intend just to make a couple of opening comments and maybe just go on to the specific sections if that's if everybody's happy with that.
Yeah.
In respect of the bill overall, the Society is broadly supportive of it and many of its provisions, including the portable criminal records disclosure, expansion of live video links where appropriate, introduction of violent offences prevention orders, a victim witnesses charter, and the abolition of the upper age limit for jury service. In respect of the matters that we have specifically responded to in writing, I'll start with the first being that of single jurisdiction for the County Court and the Magistrates' Court business. We are in general supportive that the Chief may distribute and transfer business across the different administrative court divisions to allow greater flexibility than exists at present. However, I think it was Mr Few and Mr McCartney both mentioned the issue of how you balance that in a measured way so that effectively there is not inaccessibility of courts for victims, witnesses and defendants. And I suppose the easiest example of a scenario that might arise would be a youth court, which could easily be established perhaps in Belfast and would require ultimately young people from around the country to travel to that court in Belfast. And whilst I suppose on the one hand that would be very cost efficient for the court service, it would be very difficult for young people to make those travel arrangements, can result in adjournments and consequent costs in respect of the legal aid fund and other areas. So I suppose overall the Society's suggestion that is in essence the provision is strengthened to allow that where the Chief Justice or the department where relevant makes directions in respect of the administration of business, that is balanced or certainly in the exercise of those directions the decider takes account of accessibility for court users. It also seems, I suppose, a matter of practical common sense that in any reappraisal or redrawing of administrative boundaries, there's consideration or learning gained throughout that period in respect of how accessible courts have been to the respective users to allow, I suppose, better transfer of business around Northern Ireland. Just to have a couple of maybe more minor points just in relation to the drafting. Firstly, in respect of Clause 3, subsection 7, I would think it's sensible that a provision is provided that require that the department in making any directions in respect of the administration of its business essentially consult with the Lord Chief Justice. I think on the whole what we wouldn't want is essentially the Lord Chief Justice to be making directions in respect of where court business goes and perhaps the department taking a different view. And I suppose finally another point in respect of the actual detail is in respect of Clause 5, subsection 2, which details that justices of the peace be appointed by the department by instrument. As I understand it, Justice of the Peace had carried out effectively judicial functions that lay magistrates really carry out since 2002. So it seems to me that if there are justices of the peace that are still in existence and still carrying out some sort of judicial functions, that actually their appointment be made by NIJAC and not by the department, as would be normal. So if there's any questions in respect of that section, I will do my best.
Do you want to take us through the rest of your sections and then I'll come back to each section, if that's okay?
If that's more
yeah, that would be great.
In respect of the abolition of preliminary investigations and mixed committals, you see obviously that Clause 7 and 8 provide for abolition of essentially oral evidence being provided. I think the committee is very au fait with the fact that the presenting of oral examination is on the whole unusual. I think it's 93 from over a 3-year period from 2011 to 2013, and of those 93 PIs, 16 did not proceed to trial. I take on board what the PPS or what Mr McGrory has commented in respect of that, and I'm most aware of how difficult it is for witnesses to have to give evidence twice, in essence. But there is an element of sifting, if you like, that will prevent cases which shouldn't really proceed from being sifted out at an earlier stage, and thus avoiding what may be an expensive and unnecessary trial. So I think a more measured approach would be if the district judge had a limited discretion basically to allow the calling of key witnesses where in his interests he believes that it, or where he believes that it's in the interests of justice to do so. And I think that still allows some element of safeguard, but would mitigate against any risk that that ability for a mixed committal is not abused, or the call for a mixed committal is not abused. I was also very interested to hear Mr McGrory's comments in relation to the abolition of a committal, and that if you simply abolished a committal, it will effectively reduce delay and will put greater pressure on the prosecution service and will bring cases on more quickly and more efficiently. And I think if that is to be the case, then there has to be within that structure a fair procedure to ensure that the defendant is ultimately aware of what the case is that he's actually facing. So, you know, I suppose the way the committal works at the moment is that from when a defendant enters into the magistrate's court to when he effectively leaves it at the end and is committed to the Crown Court, during that period the prosecution are essentially gathering their evidence, and ultimately the defence is essentially waiting to see what might emerge at the very end of that process. When you get to the stage of committal, at that point the papers are served, so the defendant is actually aware of what the case is that faces him from the prosecution's point of view, if you like, that the evidence from the prosecution has effectively been completed. The committal procedure itself is to effectively confirm that there is, on the face of it, a case to answer, and at that stage the case is moved forward to the Crown Court. So whether you abolish the use of the word committal or you seek to put in a different procedure, I think you have to be sure that whatever procedure is put in place, it ensures that effectively the defendant is aware of what evidence it is that he's facing. And I suppose I noted with interest Mr McGrory's comments that, you know, maybe that should more effectively be carried out in the Crown Court than in the Magistrates' Court. I mean, I can't really comment on that. I think you would have to look in respect of costs and, you know, maybe more deeply into the elements of delay. Certainly, it would be perceived that much of the delay that arises in prosecution cases is often where police are gathering evidence, forensic evidence has to come in, and all of those type of issues that are rarely swift. So, moving on to prosecutorial fines, in essence the Society has no particular objection, or otherwise they're essentially another element in the armoury of, I suppose, discretionary disposals that help, I suppose, get rid of business in a manner which helps ensure that court time is not ineffectively used. I suppose I have a couple of points in respect of how the procedure works, and the first is that when the notice of offer is effectively served or is issued, actually, there's 21 days for the defendant to indicate his acceptance of that notice. I think care has to be taken, or consideration should be given to the 21-day period taking effect from the point of service rather than the point of issue, because you could have a scenario where the Public Prosecution Service are essentially issuing a notice of offer, but the defendant has moved away, or he's in hospital, or he's incapacitated, or there could be a number of different things that occur so that that person is actually not aware of the notice of offer being issued. So I think maybe the committee might want to take that on board. Another element in respect of the prosecutorial fines is in respect of an extension of time to pay. Essentially, there is, I think, up to about £200 that the public prosecutor can effectively detail as being the appropriate amount that's payable. And there's no provision within the legislation that allows for any extension in respect of time to pay that. and that would not, I suppose, reflect the current situation if somebody is fined as a result of appearing in court. The defendant at this moment in time can, if he shows that he's of limited means, look for an extension beyond 4 weeks. And I think that's something that should actually be embodied within this clause. Another element in respect of this clause is in relation to the enhanced sum. The enhanced sum is obviously the amount that it becomes payable in the event that somebody does not meet the fine on face of the prosecutorial notice. But the enhanced sum is calculated as being 1.5 times the amount of the prosecutorial notice. And that doesn't take into account then if somebody has actually paid part of the prosecutorial notice. So potentially you could have a scenario where somebody has paid 95% of the prosecutorial amount, but hasn't been able to pay the last 5%. But if it's proceeded, if the prosecution ultimately proceed to have that registered, it'll be the entire amount plus 1.5 times. So I think with Section 75 equality issues, the committee might want to consider recommending a change to that. I suppose in general, in respect of discretionary disposals, I understand the Criminal Justice Inspectorate are looking at how discretionary disposals are being utilised, and I know, Mr. Few, you raised the issue in terms of when these disposals are utilised. And it was interesting to hear that the Public Prosecution Service are basically saying that there will be, I suppose, guidelines in respect of how those notices are utilised. And I suppose in all there has to be care taken that these notices are not actually considered something akin to paperwork. That there's so many that any person can actually, I suppose, receive before they lose all credibility. So, moving on to early guilty pleas. In respect of Section 77, where the court is basically obliged to give an indication in respect of what that judge would have sentenced had the defendant pleaded guilty at the earliest reasonable opportunity. I suppose there's two things I query in respect of that. Firstly, the point of the exercise. The most likely consequence, I think, would be an increased appeals on sentence, where you may have a defendant saying that actually he should be sentenced at the lesser amount because he wasn't appropriately advised at the earliest reasonable opportunity to duly plead. And the second issue I have, obviously, is how you determine when is the earliest reasonable opportunity to plead. You'll have heard, I suppose, Mr. McGorry, I suppose, discuss maybe a number of different time periods when the earliest reasonable opportunity may be considered. It's difficult, I think, to be very prescriptive about that because every case is different, and it very much depends on the evidence that the defendant may have been aware of. Aside from all of those very practical issues, I think it's also very difficult for a judge to say what he would have categorically sentenced had the person indicated a plea at, say, 6 months ago, because invariably the circumstances will have moved on. The defendant may have shown no remorse, in which case it's unlikely that there would be any discount, or the defendant may have made reparations, or there may be mitigating factors. The probation service would have obviously been sought for their view in respect of whether this person is of risk or is, I suppose, of risk to the public, and whether there's a continuing risk. And all of those things are, I suppose, maybe an art rather than an exact science. So to say what a judge, or for a judge to be definitive about what he would have sentenced 6 months ago, I think would be a very difficult task. So in respect of the duty of a solicitor to advise a client about early guilty pleas, well, I am similarly in agreement with Mr McGorry that it doesn't make sense that the burden, if it's to be made a statutory obligation, sits with a solicitor only. It seems to make more sense that it is with the solicitor advocate or the solicitor or or counsel. But in any event, I think it is wrong in principle that there's a statutory obligation put in place for a solicitor to advise their client in respect of an early guilty plea. Presently, a solicitor's duty is to advise their client in their best interests, and that duty is ongoing, and it commences in criminal cases, usually in the police station. When a solicitor is fully informing their client and giving proper advice, that solicitor themselves needs to be aware of exactly what the case is that is facing their client, and needs to be, I suppose, fully au fait with the entirety of the circumstances. And that ordinarily doesn't come to light until quite some considerable time down the line. Going back to, I suppose, the procedure at the moment, again, the defendant starts in the police station, he moves into the magistrate's court, he continues on to the point of committal, and at the point of committal, primary disclosure is effectively provided by the prosecution. That primary disclosure is basically the evidence that the prosecution are holding that would make a prima facie case to answer, in essence, but it's no more than that. Then, when the case is shifted to the Crown Court, you're into a circumstance where the defendant is arraigned, and at that point he has to determine whether he's going to plead guilty or not guilty. If he does not plead guilty, then he has to make a defence statement, and on the basis of that defence statement, you make an application for secondary disclosure, and it's that information that's provided at that stage that the prosecution may be holding, which would actually undermine their case. So you're quite some considerable steps down the line before you're aware of, I suppose, the evidence that is held by the prosecution against the defendant, and the evidence that the prosecution may be holding which would undermine their case. So, I suppose going back to the point of trying to determine when is the earliest reasonable opportunity, it's quite a difficult task. It seems to me that perhaps the easiest way of dealing with this is really the judge giving a warning in respect of it, and as you've already heard, that's really what's happening on a common basis. In respect of the case management provisions at clause 79 and 80, you'll have already heard Mr McGorry mentioning that the Lord Chief Justice has issued practice directions in relation to case management, and I think that's correct, and as it should be. There's a duty in all of us to make sure that there's as little delay as possible. But it also seems incorrect that the clauses provide that the department make those regulations. I would think that's a usurping of the judge's judicial function, and actually clauses 79 and clauses 80 should refer to the judge essentially issuing those practice directions. And finally, in relation to the public prosecutor's summons, I have to confess I wasn't entirely sure to what extent the issuing of a public prosecutor's summons actually reduces delay, but Mr McGorry obviously has given evidence that in his view it will reduce delay. In any event, it appears to be that a summons still has to be laid before a lay magistrate. But it looks, in terms of what the lay magistrate can do, if they disagree, it's essentially nothing. It seems a pretty toothless check, if you like. So that is really the height of it.
Okay, thank you very much. I'm just going to go through it now in terms of the run order. So Is any members any questions in relation to single jurisdiction?
Yeah, thank you, Chair, Deputy Chair. Just on the point that I raised in the last decision and you brought up, Arlie, with regards to the balance that can be struck for the jurisdiction, and it talks here in the bill, the face of the bill, about directions may specify different administrative court divisions for different courts for different purposes of the same court. Explain to me, if we one jurisdiction, what does that mean?
Well, as I understand it, basically the Lord Chief Justice can effectively determine, because it's sort of his judicial function, where work essentially resides around the respective courts. At this minute in time, if you commit a crime or there's a cause of action that occurs in County Down, then it's only courts within County Down that can actually hear that issue. So this facility basically allows for that issue to be heard County Tyrone or somewhere else. So it's to, I suppose, build in flexibility into the system and allow the shifting of work. You'll see in clause 2, the department can accordingly then make administrative changes to allow the chief clerk type of functions to be carried out in a way that would similarly be cost efficient.
So that's basically tidying, clause 2, part 2, is actually just tidying up the administrative side of things.
Well, it would be more than tidying up, because at this minute in time, there are certain functions that are carried out, for instance, by the chief clerk or the clerk of petty sessions, and again, that has to occur in the relevant jurisdictions. It really can't be shifted. So liquor licensing is one example, and in Uri, the functions of the chief clerk and respective liquor licence have moved to Armagh or maybe Uri, whichever way around. But arguably, when this provision becomes effective, that entire function could take place in Laganside.
I know that you don't disagree in principle with the single jurisdiction, but you seem to suggest, and forgive my ignorance on this, you seem to think that more can be done in clause 2 to tighten it up now, as opposed to wait for guidelines or for...
Well, I think it would be a fairly simple amendment to basically detail that the department, after consultation with the Lord Chief Justice, taking into account accessibility of court users, can make X, Y, Z amount of directions. I suppose it just puts an onus and a premise on the idea that, you know, not everything should be cost-driven from a court service point of view.
But how do you get that down in writing? What will X, Y and Z look like, in your opinion? What should it look like?
I would put in taking into account accessibility of courts to ensure access to justice, something along those lines. It just, I suppose, highlights the view that really, you know...
But can you put a mileage on it? If you know what I mean. A long journey here is totally different from a long journey in America.
Yeah.
How do we get guidelines that's robust and secure and secures that balance with regards to having an efficient core system and allowing that flexibility? How do you get that balance on paper to safeguard that?
Well, I suppose it's really, if you're talking about guidelines, I would imagine it would be for the Lord Chief Justice to basically detail guidelines as to how, and it's probably, I'm sure, something that would be done in any event, to ensure that if there's any massive changes in respect of courts, that it's done in a measured, sensible fashion. You know,
how hard is it for you and your members? Sorry, how hard is it for your members who practice have office based maybe somewhere in one town? How difficult is it for you then to go to a different county court to actually practice or serve your
customers?
Well, I suppose it's not that it is difficult to travel. I suppose it's just additional time, basically, to get from A to B. So, you know, I suppose there's various difficulties that really arise when you have defendants being sent to a court that is exceedingly outside their area, because they become very dependent on the public transport system. So, for example, the family care centre for the South Down area is actually Craigavon, where it's County Down. It actually covers a huge area, but you might have people from South Down or South Armagh who find it actually hugely difficult to get buses and X, Y and Z to get to Craigavon Court at 10:30 in the morning. And quite often there's difficulties with people coming late or them not coming at all. And that obviously has consequent impact on the court's time.
Okay, thank you.
Mr Lynch?
Yes, Arlene, I know that the director said that go, and I think he said go full hog and just abolish. You said that the district court judge should have some sort of discretion. Could you elaborate a little on that?
Is this in respect of committal?
Yeah.
I suppose what I'm trying to suggest is a measured approach that basically there isn't overkill in respect of dealing with a concern in regard to mixed committals. So at this minute in time, you could say that the ability to call oral evidence provides a safeguard or a sifting exercise that prevents cases from moving into the Crown Court that really shouldn't move into the Crown Court, should effectively stop dead. But I have to take on board that it is stressful for witnesses and for victims to feel obliged that they are obligated to give evidence twice. So I am suggesting that a balanced approach would be to provide some sort of a discretion to the district judge to grant a mixed committal where he believes it's in the interests of justice to do so. And I would imagine that an application of that nature to a district judge would be unlikely to be frequent. As I said, mixed committals are not very common anyhow, but I would similarly imagine that any district judge would take a very narrow view in the exercise of that discretion. It would be more than just, I don't agree with the contents of their statement as presented on paper. I think it would be, it would have to be much more than that.
Mr McGuinness.
Thank you very much, Chair. Just one point first of all, in relation to this common jurisdiction. Does that mean that county court judges and magistrates really have no fixed position, or what are the consequences of that?
Well, I would imagine that under Clause 3, the Lord Chief Justice could effectively move magistrates or county court judges around
at will.
So, yeah.
So the county court judge for Fermanagh and Tyrone, he would be notionally that, but he could be anywhere.
I mean, I know that the movability of judges is of particular concern in the continental jurisdictions, where they have more of a notion that, or more of an idea that to ensure independence of the judiciary,
yes,
you cannot really be moved from your position, because
yes,
it would, you would be subject to undue pressure, if you like.
I've asked the question before, sorry for interrupting you, but I've asked the question before to officials, do the judiciary, have the judiciary expressed any concerns about this? And I'm told they haven't expressed any concerns, either the Magistrates Court bench or district judges as they are, or the county court judges. Now, I don't know what the situation is, but I would like a reassurance from the department that that is the position, that they are not concerned about this, that they're quite happy that they can be moved about at will and have notional titles, or maybe have no titles whatsoever, which I think would be regrettable. Anyway, that's by way of comment. In relation to the situation with regard to committal proceedings, I do take the view that that mixed committal proceedings should remain, and I agree with you at the discretion of the district judge or the magistrate, because I think it is a good way of weeding out bad cases, weeding out weak cases where the evidence is questionable, and there should be an opportunity for the court to hear that evidence and deal with it. Would you agree with that?
Absolutely, yeah.
And just in relation to vulnerable witnesses, particularly women who may have been the victims of sexual crime, that they should not be forced to give evidence in circumstances where this gives rise to trauma or re-traumatisation, and that should be made very plain. Would you agree with that?
I don't disagree with it. I think that a very narrow approach can and should be taken in relation to the exercise of any discretion by a district judge if he were so minded to agree that oral evidence be provided.
Just one final point. You did refer to some figures. You referred, I think it was 93 PIs over a period of 3 years.
2011 to 2013.
Yes. So that's roughly 30 or thereabouts per year. What about PEs? How many PEs would there be?
I think in the last year there was 1,600.
1,600?
Roughly.
Yeah. So you're dealing with a very small number of cases in any event.
Yeah.
Yeah. Which leads me to ask the question, which you might be able to answer. Where is the savings either in time or in avoiding delay or in terms of cost? Have you any observation to make on that?
Well, I think it's the Department's view that overall this bill may improve administration of justice, but I don't believe they see it as being, I suppose, producing cost savings as such.
Right. Okay. Thank you very much. There are other issues out there that we will come to. Or?
Yeah,
okay.
there is.
Thank you, Chair.
With the single jurisdiction, and we kind of moved into committal, so
All right.
Mr. McCartney, had you?
I mean, it's just to follow on, excuse me, from Robin's point, your position is that the committal proceedings should only take place at the discretion of the district judge?
Well, the I suppose mixed committal.
Mixed committal, sorry.
Yeah, but I think, you know, I was interested to hear that Barry McGrory was advocating a view that actually committals in its entirety be abolished. And, you know, whilst I have no objection to the word committal being, I suppose, abolished, there still has to be a fair procedure that's in place to ensure that the defendant is aware of the case that he is ultimately facing. And I think it's very hard to get around, I suppose, the procedure that's built up over the years, that effectively it's where you have a serious case that ends up in the Crown Court, that in essence the prosecution's case is effectively put together when you're at the magistrate's court stage. But you know, whether you get rid of committals, there has to be a fair procedure to ensure that the defendant knows the case that he's to face.
What sort of system, I mean, should we have in place to ensure that it is fair? You know, so it isn't sometimes, you know, I mean, in fairness, some of these cases sometimes can just be a serving of papers. There's no real examination, but we move on. In some cases, there might be a need to examine the strength of the evidence, the quality of evidence. So how do we put in place, you know, where something might have been built up over a number of years, but that doesn't, you know, preclude the need to maybe change it?
No, absolutely not. And certainly, as I read the provisions of the bill which allow direct committal in respect of murder and manslaughter, from the body of the clauses, it still appears that the prosecution must serve their papers when at the end of, I suppose, that person being in the magistrate's court. So, you know, you still need a process there so that the defendant ultimately has a block of papers and the legal representative can look through it and give them advice accordingly.
Okay.
You know, I don't really know how you, in essence, dispose of that in a manner which ensures that a defendant can actually meet a case.
Okay, thank you.
How do you answer the charge that Barra made, though, is why have it twice?
Well, I go back to when I think Barra was making a point in respect of having a position where somebody might have to give evidence twice. And I am firmly of the view that actually that discretion in respect of somebody giving oral evidence should be at the discretion only of the district judge and would be very, very limited. In relation to Barra's comment, why somebody needs to get papers twice, well, you get your primary disclosure at the end of the case in the magistrate's court, and when you move into the Crown Court, you effectively get served predominantly the same set of papers again, plus your, I suppose, charge sheet upon which you will be arraigned. And, you know, perhaps there is a method of not duplicating paperwork twice, but, you know, there may be a method of doing that in a simpler fashion. But you still, a defendant still has to be aware of what he's facing ultimately.
The figures that you provided in terms of the 93 PIs, there's that few. Why is everybody not engaged in PIs and PEs if it's so fundamental to fair trials?
But it's not fundamental in every single circumstances. I mean, the vast majority of cases, you've heard the figure 1,600, it's, you know, it will be evident from the papers that are served that there is case to answer. So, you know, there's very, very limited circumstances in which, as a legal representative, you would say, well, actually, we need to go beyond this and raise oral evidence at this stage. No, it's used infrequently, but what I'm saying is that because it's not abused is I suppose the point, and I don't see a need to get rid of it if it does provide some sort of a safeguard in getting rid of cases that really shouldn't be going forward.
Mr. Poots?
Yeah. How would you make it more efficient then?
In terms of...
Well, I asked Mr. McGrory the three principles. Number one, did it diminish the quality? And he said it didn't. Two, would it improve efficiency? And he said it would. And three, would it be more effective? And he said it would. So you have came along and basically said that what he's saying doesn't stack up. So, you know, how would you make it more efficient? Because it isn't good that it's 8 to 10 weeks that goes through. That isn't effective. And I assume that there are more effective systems in other jurisdictions that you've studied, and you'll be able to give us some of that?
Well, I can't say I've studied that many to say whether anybody else is doing it significantly better than us. I wouldn't, you know, I think by and large the Public Prosecution Service gave a very measured account to the Justice Committee in respect of efficiencies and delays, and I was equally interested to hear that in the PPS's view, if you got rid of committal, it would reduce delay by 6 weeks or something along 6 to 10 weeks, I think is what Mr. McGrory said. But if you are getting rid of, I suppose, the word committal, you still have to ensure that there is a fair process in place. And if there is something that can be put in place that is quicker but ensures that the defendant is still aware of the case that he has to effectively meet, then, you know, I don't think that any of my members would have a particular objection to it. In fact, we would welcome reduction in delay in respect of criminal cases, or the hearing of criminal cases.
And would you welcome an amendment along the lines of what Mr McGrory was suggesting to the bill?
Well, he made a number of different suggestions, so, it depends what specifically you're asking me to agree with. Or,
well, you would work with us if some of us led an amendment to that effect, that, if it wasn't as you would believe is as high quality standards you'd like, you would work with us to refine that.
Absolutely.
Thank you.
Mr. McCarthy? In terms of the power of the district judge at the committal, is he the power to stop a case?
Not well, unless you make an application for abusive process.
Yeah. But what about the quality of evidence? See, I'll give you an example. I mean, and I don't know how this proceeded, but the trial, including the two Stewart brothers, went to trial. The way that they were then exposed, it makes you wonder if there had been a very efficient mixed committal here, then their credibility should have been spotted then. The case struck out, and then all the savings made. So how do we put up that type of protection in the system? In that case, is there a situation where the defence don't apply for mixed committal and let it run the trial?
Invariably, the defence does not apply for mixed committal.
Yeah.
Invariably, the defence will look at the papers, and invariably there's a case to answer. There, as I said, it's very rare for mixed committal to be sought by the defence, but presently where you do so, the judge really has no power to prevent the defence from proceeding on that basis.
Yeah, but in that case of the Stewart brothers, could the district judge have said at that stage, these are bad witnesses, and if that's the basis of your prosecution, go no further?
I can't comment on a particular case.
Right, okay.
But just theoretically,
yeah.
I know that Ms. Elliott will comment on the individual case, not quite proper, but theoretically, the defence can apply to dismiss the case at that stage, and the district judge has the power to dismiss it.
Yes.
Yeah. So, it's an important power that the district judge has at that stage.
Mm-hmm.
Could I just add one further point, and this is a point, Chair, in relation to delay. This may expedite the process to the Crown Court, but doesn't necessarily make the trial at the Crown Court any faster. Could delay the trial, because at the Crown Court, counsel or solicitor will apply maybe for the case to be dismissed, or on the grounds of some deficiency in the case. So there could be the beginning of a trial could be encumbered with a whole series of applications, which could have been dealt with perhaps at a preliminary inquiry, preliminary investigation level.
Well, certainly the provisions in relation to moving the case by direct committal for murder and manslaughter would appear to allow for an application to be made prior to arraignment before the Crown Court judge, seeking dismissal in the interest of justice, and the Crown Court judge basically makes a determination prior to arrangement at that point. Is it correct that that I suppose that power is moved from the Magistrates' Court to the Crown Court, and at that point, I think there would need to be.
So it doesn't, in a sense, it doesn't really eliminate delays that could be caused in the trial process.
Certainly, I can only say that when the bill becomes operative, if there's direct committal for murder manslaughter, then yes, you could have a scenario where effectively what should have been argued at the magistrates' court is basically being argued in the first instance in the Crown Court. Is that a good use of court time? Well,
Yeah.
Okay. Any members, any other that section? Anyone on the prosecutorial fines? No. Okay, the miscellaneous element in terms of the duties on solicitors to advise the client about early guilty pleas. Do you want to just elaborate a little bit more on why you think it should be the PPS and not yourselves?
Firstly, I suppose I make a comment about when you determine the duty basically becomes operative, and the clause basically states at the earliest reasonable opportunity. Well, for the professional who is obliged to basically meet a statutory obligation, when is the earliest reasonable opportunity? Is it in the police station? Is it first appearance in court, committal, arraignment, upon provision of secondary disclosure? It seems to be, I suppose, vague on the face of it. But in reality, and what is happening now, is that solicitors have an ongoing duty to their client to ensure that they're fully advised, and that really is a matter of professional judgment, how and when you explain that to somebody. Quite often, and quite usually, defendants who find themselves in the criminal justice system are often vulnerable. They often have literacy problems, addiction issues, and a variety of different, I suppose, difficulties. So it can be quite, I suppose, an art. Well, an art is the wrong word. It can take some deal of work on the part of its solicitor to ensure that that person understands entirely what is happening, and that you are fully aware yourself of the case that that person is facing, so that you can give appropriate advice to that person. So I query whether putting in a statutory obligation that a solicitor must advise at the earliest reasonable opportunity about an early guilty plea is taking a sledgehammer to a nut. And I would be concerned that in actual fact you are entering into client-attorney privilege, and that effectively the balance is being changed so that you are not independently advising your client, but you're carrying out a function of the state, if you like. And I think really on the balance, it should really be the judge who gives a warning, if you like, in respect of proceeding to trial where perhaps that person needs to be aware of the risks that that will arise if ultimately they're found guilty. You know, I suppose I go back to the issue that again was raised by Mr. McGorry in respect of whether there should be a statutory deduction in respect of sentencing if you've entered an early guilty plea. And to be frank, I would be concerned that such a statutory deduction be put in place, because again there's a myriad of different circumstances that can arise in any court, and you could have a defendant who has absolutely no remorse, is extremely proud of doing what he or she did and says so from the get-go, if you like. Now, that person would be provided a statutory reduction for an early guilty plea seems to me to absolutely fly in the face of good justice. So
would that be the norm? Would that not be
well,
an exception to the rule?
I suppose you have.
Is it not really people who are guilty of sin, but they're going to try and use the system to see has every I been dotted, has every T been crossed, And only at that point, 28% of them who plead not guilty, before the case goes to trial, have changed their plea because the state has been able to provide the evidence that is obviously pretty irrefutable, and therefore the change. Is that really not normally the type of people that we're dealing with?
Well, I think actually it would be useful to look deeper into the statistics of the 28%. I would imagine that there are a number of different factors that bring about, I suppose, somebody's change of plea prior to trial or upon arraignment, and that can be amendment of the charges or an agreement or an understanding in respect of facts. You can have, and it's not uncommon, to have a defendant who says, I did A, B and C, but I didn't do X, Y and Z, as is being alleged. So on the face of it, they are pleading guilty, but it's not on the facts that the prosecution would seek to persuade the court is the case. So sometimes you have hearings before a court in respect of the facts only, with, I suppose, an understanding that the defendant is pleading guilty to a certain factual scenario. So I suppose I think it's too simplistic to say that 28% of people change their plea at the last minute and they should have pleaded much, much earlier.
Well, I suppose we've asked for those figures, but Barra did seem to indicate that it was related to the exact same charge. It wasn't a case of an amended charge and now I'm going to accept guilt. So I think you're right on that, we do need to get it. And I've some sympathy about the judge having to do it, although if you're going to give the best advice to your client, surely there is a responsibility on the advocate to be saying to them, listen, the evidence here, you're in all likelihood you're going to be found guilty. You really should be considering pleading guilty because sentencing will be taken into account.
Well, certainly that is not always, sometimes a conversation you have where, and I suppose it's when you have it, and it's ordinarily after you have obtained secondary disclosure, so that there has been further exploration in relation to maybe the case that has been, or the instructions that have been given to you by the client, and maybe upon provision of that secondary disclosure, there are anomalies which are, not sensibly explained, if you like. Again, it's very difficult to be entirely prescriptive because every circumstance is different. But when, I suppose, you have a client who gives a set of instructions that just do not match in any respect, either the paperwork or there's nothing to assist in what they're saying, then obviously you have that conversation about whether, in all likelihood, their evidence is likely to be believed.
And this is my ignorance, but would the advocates ever ask their client, are you guilty? Am I naive to think that people who commit crime would actually say to their solicitor right from the start, listen, I'm guilty, but what can you do here? How can you get this to a point where I might get off it, or I might have a reduced sentence? What needs to be done?
You sometimes have a client who will say, I am guilty, or I did X, Y and Z, and your ethical obligation is obviously to represent that person on the basis of the information or the instructions that they have given you. So if this person has said, I am guilty of theft, then you will be proceeding to ultimately enter a plea for that person. But that person may say, well, I am guilty of theft, but I don't want to plead guilty, in which case the prosecution have to prove their case. But you can never call perjured evidence, and you can never make a case on behalf of that person that they didn't do it.
But if you're then asked, if there's a requirement in this bill that a judge will have to ask, as Barra indicated, the advocate, have you advised the client about the need, about pleading early, a guilty plea, and the impact that could have on sentencing? Do you need to take instruction from your client to be able to answer that? If they've told you, I'm guilty, but I'm not going to plead guilty?
Well, obviously, if you've had somebody who've said, I'm guilty, and I have to stress, it would be most unusual for anybody to say I'm guilty, but I want the prosecution to prove their case. But if you had those somebody that wanted to go down that avenue, you would be putting very strong advice to them about the risks they're running.
Okay. Mr. McCartney?
Again, it's back to, I mean, I think when you read 23(1) of your presentation, there is provision that it's part of the professional obligation to provide clients. No, so legislating for it seems to be where the issue is. Right? Yeah. Legislating for it, right? And this sort of idea, where is the most appropriate time? So, and how do we square? Do you think it should run as it is, or is there any room for, you know? And it's not so much. I mean, the idea of encouraging someone, you know, I think it's the wrong terminology anyway, because it's nearly pushing someone into a position where they shouldn't be. So but at the same time, it's giving people, you know, full appraisal of the facts. In other words, where they might feel, you know, in the scenario you've outlined, there might be situations where a person has done A, B, and C, but not feel it's F, G, and H or whatever. So how do we frame a system where people are getting justice plus that the system isn't unnecessarily clogged up and someone hanging on in the hope that they might get something extra?
I think a couple of things about this. I think what can sometimes be missed in statistics is these are all individuals who are entitled to justice in our system, and it's our collective responsibility to ensure that we have a system in which we all, and each of us, has confidence. What it appears to be missing from this particular clause is any reference to the fundamental principle that the defendant's plea must always be made voluntarily. That's entirely missing from this. You think about vulnerable defendants, you think about vulnerable children. Where in this provision is there any specific provision as to how, you know, children or young people might be treated differently? And then secondly, thinking about the system and the person's right to a defence and to proper access to an adequate and compliant justice system. Where is the how will that defendant feel, particularly if they're a vulnerable defendant, about being advised by their solicitor that there are advantages, you know, if you plead guilty? So I think what we have at the moment is a very balanced and very measured and appropriate system, as the Vice President has referred to, that actually works quite well in practice. If it is the Department and the Assembly's will to introduce a provision of this nature, which I think the Society would oppose in its current form, then I think at the very least what needs to be added is some balance to the clause to take account of vulnerable witnesses of all descriptions, take account of vulnerable defendants, and to introduce an overriding principle that the defendant's plea must always be made voluntarily. I think that the suggestion that the duty might fall on the judge at a particular point would make it at the very least a procedural requirement, which would ensure that the defendant was aware, might remove any undue pressure from people who were vulnerable or who might inappropriately plead guilty to a set of circumstances that was not relevant, as the Vice President has said.
Okay. In terms of the process in place, you know, is there a process in place where a defence lawyer can go to the prosecution service and say, my client will plead guilty to actual bodily harm rather than grievous bodily harm?
I defer to the practitioner.
There's not a process in place as such, but in the ordinary course of a case, quite often prosecution and defence will have a discussion about what can be agreed and what is not agreed. That would be entirely common. What doesn't happen is plea bargaining. You can't have a scenario where the defendant or the defence is saying to the prosecution, we plead to this if we get that. That wouldn't.
But I mean, in that scenario of grievous bodily harm, because there's no particular case, no actual bodily harm can't be appealed, the sentence can't be appealed, but grievous bodily harm can.
I defer to your better knowledge on it.
I just know, and that's where the interest of a victim. This was obviously a domestic abuse case, so a person gets convicted of actual bodily harm. There's no provision then, for the prosecution service to appeal it.
Or do you mean if
Leniency of
prosecution
sentence.
reduce it?
Yeah.
And
So, I mean, and that's the other part of, where people quite rightly, and Alan has said this, about the voluntary plea. But in terms of a witness, in terms of a victim, what's the process that protects someone where a prosecution service does feel that they have, in the first instance, the evidence to go for grievous bodily harm? But you have a process which is, I mean, people talk about agreement and, but when you look at it from the outside, it's a short step from plea bargaining, and sometimes it's not in the interest of justice from the person who has suffered the grievous bodily harm. Mm-hmm. Particularly when they're told afterwards, no, this can't be appealed because it was actual bodily harm, but if it had been grievous bodily harm, you could have. So how do we at that end of it as well?
You go.
I suppose in terms of the victim, they have their opportunity to make a victim impact statement, and as you've heard, the Victims Charter may help ensure that victims feel more part of the process. But I think, Mr McCartney, the issue you're raising is in relation to victims feeling that the prosecution haven't maybe fully represented what they feel to be the position from their end of it. And I think really the Victims Charter might assist in, I suppose, how issues like that arise going into the future. I suppose that is a different issue really to one where the defence will really look at it so much from that side of things, if you like.
You see, I mean, in terms, and Barry McCrory said this, I don't think any of us want to see a plea bargaining situation. Mm-hmm. But sometimes when you have provision, and it might be well placed in terms of the framers of this saying, you get an early guilty plea, it saves everybody costs and all that goes from it, right? But I think you're starting to build into the system, because someone might come along and say, my client will plead guilty, and I'm not saying will plead guilty early if it's reduced from grievous bodily harm to actual bodily harm. So, in one sense, the system might be saying, that's good justice, it's fair, and all that. But the victim is looking on and saying, no, how are we protected from plea bargaining and from using one provision that might look good on paper and in theory, but in our way can be used as part of the plea bargaining, and we can call it whatever our name we want, but in essence it becomes plea bargaining.
Well, I suppose in essence, fundamentally how the case proceeds from a prosecutorial point of view will always reside with the prosecutor. And you naturally will have issues where victims do not agree with maybe an approach taken by the prosecutor, but ultimately it has to be the prosecutor's decision in terms of assessing, I suppose, the evidence that's available to them and the likely outcome if it proceeds to a court. And I can well imagine that victims can sometimes feel excluded from that process and from maybe the thinking behind it. But it's very difficult to, in fact, to get away from, I suppose, the prosecution having the ultimate say in terms of how the matter progresses.
Okay, thank you.
Mr. Page?
It's covered.
Mr. McGuinness?
Thank you very much, Chair. Just in relation to the to Part 8 and Clause 77 and 78, the duty rests with, or the proposed duty would rest with the solicitor. It doesn't rest with a barrister.
No.
Or does it rest with a solicitor advocate?
Well, on the face,
There would be a question mark there.
certainly on the face of the clause it refers to the solicitor, and I suppose that would raise, I suppose the concern that the intention is possibly that the earliest reasonable opportunity is the police station.
Yes, true. But if it gets to court and the solicitor says to the client, by the way, I think you should plead guilty here, an early plea, you know, you'll get discount to all the rest. And by the way, I'm going to instruct counsel to conduct the plea in this case. Counsel receives the papers in the case, looks at the papers and says, by the way, you're not guilty of this offence or these offences. I've looked at the papers and I've discovered that you really could not be guilty in the circumstances. Take, for example, road traffic offences, where counsel looks at the paper and says, well, actually, this was not a public highway, it wasn't a public place. Therefore, you're not guilty of any offence, road traffic offence here. So you could have a very peculiar situation where there's a conflict between what counsel's assessment of the case and what the solicitor has advised the client. I know that might be far-fetched, but nonetheless there is a potential conflict there. Is that not true?
Absolutely, yeah.
But why I'm uncomfortable with all of this is that I think it all conspires to force people into pleading guilty in circumstances where they may be innocent of the charges that they're faced with. And I think that we're now establishing a process where more and more, because of the efficiency of justice, because of the expediency of justice that and dealing with trials and so forth, that people are going to plead guilty, and they shouldn't be.
Well, certainly, and I suppose it's going back a little time now, but the right to silence has effectively been limited and reduced to an extent that when you're providing advice to a client in a police station, it can become quite difficult to give proper, full advice. And I suppose this additional statutory duty to advise in respect of an early guilty plea is the next step. There's no doubt.
The other thing, and I note at paragraph 25(1), you say, it's notable that in Scotland the procedural reforms to the system of encouraging appropriate early guilty pleas focused on disclosure from the prosecution service. Is there an issue at all here in relation to disclosure from the prosecution service? And I apologise, I wasn't here when the director gave his evidence.
Well, certainly, and I don't have the evidence for it, but it is believed that we would find in Northern Ireland much greater difficulty in basically obtaining evidence that ultimately require a number of different applications for disclosure ultimately being made in the Crown Court. But, you know, it is something that would have to be looked at, I think, probably in a statistical fashion.
Yes, and just the final point, Chair. Should the duty, I know there is a duty, an inherent duty on any solicitor to advise their client in a situation where he comes to the conclusion, look, it would be advisable for you to plead guilty. Now, leaving aside that duty, which is a professional duty as opposed to a statutory duty, should the real duty not lie on the court and on the judge to say to the defendant that if you enter into an early plea, there would be a discount in relation to sentencing?
Yes, absolutely. I think that would cover any concern that a defendant isn't aware of the benefits of an early guilty plea in respect of sentencing. So it will have been said in open court, and all can be assured that the defendant has heard it, if you like. And I think that is a more appropriate way of doing it than placing a statutory obligation on a solicitor. And I suppose one maybe small point I didn't raise was the final clause of that basically details that any person can make a complaint to the Sisters Disciplinary Tribunal where, or in respect of breach of that solicitor in failing to advise. I would be concerned that that would actually be utilised or abused by anybody who may be engaged in criminal proceedings and use that procedure basically to undermine a solicitor simply carrying out their professional obligations.
Thank you very much, Chair.
Any other questions on that now? Finally, have you a view on the rights of audience issue that was discussed earlier?
I was interested to hear the public prosecution's view in respect of it. I mean, I suppose insofar as the society is concerned, we would be very concerned that if you have the Attorney General's office, the Public Prosecution's office, and maybe a multitude of other offices, basically looking to, I suppose, avoid part of the regulatory framework, we end up with a very piecemeal sort of framework, if you like, which I don't think would be, I suppose, healthy, for want of a better word. It also seems to me that the Attorney General's representations that somebody that's simply working in his office shouldn't have to go through those regulatory hoops, if you like, would invest, would mean that it would centre around the personality of the Attorney General, and that seems to me not a sensible way to regulate. So I would actually be opposed to piecemeal exemptions being made across the board.
But if the Attorney General, or for that matter the PPS, have to use a self-employed legal professional, surely they're going to be acting under the instructions of the PPS and the Attorney General anyway. So, for want of a better phrase, the personality issue surely doesn't really stand.
There seem to be two separate issues emerging. The prohibition, which I heard discussed this afternoon, is a prohibition of rules. It's as I understand it from the conversation, a function of the bar rules, that if you are an employed barrister, you may not appear. There's a different issue then in relation to solicitors, because that prohibition doesn't apply. And as you know, we're putting in place a regulatory structure that would enable solicitors to exercise rights of audience in the higher courts. So what we're saying is that, you know, those solicitors who would be employed by the PPS or by anywhere else would not have that prohibition. The prohibition for solicitors comes from the prohibition on the rights of audience in the higher courts, not from any internal rule. So it appears to me, just from listening to this afternoon's conversation, that there might be two different issues.
Okay. Can I thank you very much for coming to the committee? Appreciate it.
Thank you.
Okay, members, the next oral evidence sessions from Women's Aid, if I would like to come to the table. Pages 71 to 74 of the meeting folder has the relevant information. And we're joined by Ms. Louise Kennedy, who's the Regional Policy and Information Coordinator, and Ms. Sharon Burnett, who's the Management Coordinator for Causeway Women's Aid. And you're both very welcome to the meeting. As with the previous sessions, this session will be recorded by transcript, and the transcript will be published in due course. And similarly, I intend to ask that you briefly outline the key issues in your document, and then members will go through it section by section and ask questions at that point. So if everyone's clear, we'll proceed, and I'll hand over to yourselves at this stage.
Okay. We just want to start with giving a brief summary of the services delivered across Northern Ireland, because there's a great many people that don't understand the extent of the services we deliver and the necessity there is for victims to have them. We provide refuges across Northern Ireland, float support, outreach services, the 24-hour domestic and sexual violence helpline, training, support for women engaging with the criminal justice system from the very initial interaction with PSNI and the whole way through the court process. Children's services, and then engagement in arenas such as this. We have been very encouraged by the extensive work that's been undertaken by the Justice Committee and the Department of Justice to make the justice system more victim-focused, because it would be our experience that it's actually justice agency-centred as opposed to victim-centred. We'd like to preface our comments as well by saying that for victims of domestic violence, criminal justice is only a small part of the picture for them. For most victims, protection and support are gained through civil system, through non-molestation orders, through MARACs or Multi-Agency Risk Assessment Conference, and through support organisations such as ourselves. While non-molestation orders are a civil issue, it's the very first contact that the vast majority of victims will have with the court system, and it's often a very negative experience, which then subsequently paints their view on the criminal justice system. When victims of domestic violence do seek criminal justice, they're faced with a number of barriers. Re-victimisation by the system, in that they are asked to repeat and repeat and repeat very traumatic experiences time and time again. Risk of more abuse from perpetrators in relation to reprisals or intimidation for issues like withdrawn complaints. Significant delays in cases going through courts with adjournment, and I think we've heard a wee bit about that earlier on today. Very mixed messages about special measures, with some people commenting that they were never told about them, some people commenting that they were told about them but they were very much advised not to access them because it would be detrimental to the outcome of the case, and that's not uncommon for victims to be told. And a criminal justice system that we see time and time again doesn't have sufficient understanding of domestic violence, and real need for training for the criminal justice system staff in relation to that. The last thing that I'll say before I pass you over to Louise is in relation to many of the components of domestic violence are not, in fact, criminal. So the system doesn't deal with the spectrum of abuse and deals with a particular incident, but for victims, they very much see that particular incident as part of a full spectrum, so that sometimes can taint their view on the criminal justice system as well. And in the view of Women's Aid, there are real merits in having a crime of coercive control to reconcile this reality of domestic violence, but we accept that that's a discussion for another day. I will pass you over to Louise.
With all that in mind, we'd like to share our views on different aspects of the bill. And we're aware that in our submission we commented mostly on the amendments, but we were aware that when we were called for oral evidence, that we were asked to comment also on the main clauses of the bill. So we're willing to do that if the committee sees fit.
In respect of what, sorry?
Well, mostly in respect of the Victims' Charter,
Yeah.
and on the violent offences prevention orders and prosecutorial fines. If it's okay.
Please do.
First of all, we'd like to say that we welcome the Victim Charter and the work that's gone in to get it this far, and the fact that it is being placed on a statutory footing. We do note, however, that there's no statutory entitlement per se for specialist support services for victims within the bill or the Charter. Article 4 of the EU Victims Directive states that a victim must be informed about any specialist support relevant to them at first contact with a competent authority, and the directive and the guidance, the EU directive and guidance specifically mention domestic violence in that respect. We've worked with victims who would have dealt with police, solicitors, barristers and more general support services. that don't have that domestic violence expertise. And many of those victims would then have come to us midway through the process, and they would say that they had been left feeling frustrated about the process, misunderstood, and that the advice that they had been given to that point might have been actually quite inappropriate really in relation to domestic violence. When they were pointed to Women's Aid much later in the process, they said that if they had received the right expert support from the beginning, their experience and interaction with the system might have been much, much better. It also links in to the importance of identifying vulnerable victims at the earliest possible stage to ensure that they are offered things like special measures. That assessment is often done at the very early stage when police are involved. So therefore it is really, really crucial that at that early stage there is the direction and the referral to those special services, and that victims are subsequently treated appropriately throughout then the rest of their engagement with the criminal justice system. Just very quickly, I wanted to mention as well that the bill mentions the Charter may not require anything to be done by anyone acting in judicial capacity. Now, notwithstanding our appreciation of the real importance of judicial independence, our concern here is that without the proper training on specialist issues like domestic violence, many provisions of the Charter might be rendered effectively meaningless for victims of domestic violence or sexual violence as well, if they're being heard by a judge who maybe doesn't have that real expert understanding of the issues at hand. I just draw your attention to Article 25 of the EU Victims Directive that does specifically call for specialist training of judges. So in practice, the reason we say this is because that we, while we're not trying to damn the judicial profession by any means, and we do see inconsistencies across Northern Ireland in those levels of understanding and expertise. Not just training, but expert training is really important in that regard. Moving on to violent offences prevention orders, serial domestic violence perpetrators, they're a huge problem, and it is a serial perpetration issue. And some mechanism is needed there to prevent serial perpetrators from being able to move from one victim to the next with impunity. Since the introduction of MARCS, which Sharon mentioned, it would be quite actually easy to identify now who those serial perpetrators are, and even if there has been no criminal conviction there, which often there isn't, and we do recognise that those victims are victims, and they're recognised as such within MARCS and by the different agencies involved. So it's quite disappointing then that with regards to these orders, that the threshold may actually render them effectively unusable in many cases against serial domestic violence perpetrators. The reason for that is through our discussions with the Papani Victims Advisory Subgroup, it's become clear to us that these orders may not be of practical use in domestic violence cases, as most individual instances of domestic violence, as an instance of domestic violence crime, may actually have quite a low threshold. So, for example, you might have an instance of criminal damage, for example, or something that would consider to be a, quote-unquote, minor crime, yet that doesn't take into consideration the months or even years of psychological, emotional abuse, other instances of physical abuse that have not been reported. It's said that it takes 35 times for instances of physical abuse or attack before a woman will come forward in the first place. So domestic violence is a hidden social problem. When the instances of violence aren't being reported, they either that or many instances don't constitute a crime. So it's common for a case to go to court where a woman has been abused for many years or months, and what's being dealt with is something that doesn't actually bear any resemblance to the reality of the situation, and we don't actually feel maybe that these orders are going to do anything to sort of help in that regard with because of the low threshold with requiring assault occasioning actual bodily harm. Just very briefly on delay, we just welcome the statutory framework being put in place to manage criminal cases. The consequences of protracted proceedings can be enormously damaging to victims of both domestic and sexual violence, particularly the ability of that victim to retain confidence in the system and to continue within that process. It's well established as well that perpetrators of domestic violence will often attempt to use a legal process or any opportunity to further exact power and control and manipulation, and to continue to abuse that victim by maybe delaying, frustrating or subverting the justice process. And trying to put pressure for a victim, for example, to withdraw evidence. And we're of the opinion that all criminal justice agencies should have systems in place to recognise that this does take place and when it's taking place, and to try and guard against it. Moving on to prosecutorial fines. We just wanted to bring up the point that it might be worrying if crimes with a domestic motivation fell under this. If such cases were dealt with using prosecutorial fines, this might send a message to perpetrators that they can act with impunity, or that, that just a domestic myth is something that society actually does still hold dear. It would also make it possibly more difficult for something like Clare's Law in England, the disclosure law, to be potentially implemented in Northern Ireland, because many perpetrators would not have a criminal record with which to reference for those women seeking information about serial perpetrators. It would reinforce the myth that it was just a domestic, and it might deter victims from even coming forward in the first place to report such crimes, since most likely that risk, that very, very high risk in doing so, wouldn't be worth it if it's just going to be a fine at the end of the day. It could put women's lives in danger, in short. It could also have the effect of punishing victims, and particularly if finances are shared and there's financial abuse in a relationship. You could have a scenario where if someone is having to pay a fine, the person who's actually ultimately paying is the victim, because the finances are coming from that pot. Just to move on to the Department of Justice amendments, we have stated that we support the change to an opt-out system for victims receiving information about support services. Often in that initial stage, victims are dealing with an awful lot of information. They've had a very traumatic experience, and it may take quite some time for them to process exactly what's happening and what has happened to them. Having an opt-out system gives victims the opportunity to consider the support options once that initial traumatic event has passed with a clearer head, and still gives them the choice. The choice will remain as to whether they avail of those services in the end. And with regards to the amendment on criminal records, Women's Aid is in favour of a better exchange of information, given all the reasons that we've said about those difficulties with minor crimes not reflecting the true gravity of an abuser's situation. Given what we have said about that as well, we would say that the difficulties in securing convictions, the likelihood of more criminal convictions being minor, even though a perpetrator in question might be dangerous and violent, we therefore have reservations about a system that may remove any cautions or minor convictions relating to domestic violence from a perpetrator's record. I suppose that would be especially the case if, for example, that perpetrator's modus operandi would have been to target vulnerable young people or vulnerable adults, and then wants to maybe go into a role or a job or a voluntary role where they're working with such people. We appreciate the provision about having discretion regarding that kind of review, but again, we'd point out that not having any domestic violence-related criminal convictions in a very long time, like maybe for 10 years, doesn't mean that that person hasn't been a perpetrator. That there not being a conviction doesn't mean it's not still happening. And again, there are the likes of Marac are evidence of proof of this. So that is the gist of our comments on and we're happy to take questions.
Okay, well, listen, thank you very much for that. A couple of points I just want to raise in terms of the victims and witnesses aspect of it around a victim statement. Do you believe that the bill provides enough clarity in respect of how victim statements would be used by judges?
Obviously we're very happy to see it there, that the victim's impact statement is able to be used. I suppose what we'd say is that that also requires someone getting to court. So if you look at the prosecutorial fines thing again, if that is taken away from them, you're actually depriving a victim of the impact to make the statement in the first place. And those situations are absolutely vital for that victim to be able to say to the judge, to put her into society, that this is the full extent of the abuse that has occurred against me. So I do think they are very, very useful, and I think it was a very cathartic process for a victim to be able to make that statement and to go beyond what is the very narrow construction of the the criminal offences relating to domestic violence. I suppose.
Okay. And then just on the criminal records aspect, do you have a view in terms of wiping the slate clean whenever a child reaches, the age of 18? It's been a point that's been raised to us that once you reach the age of 18, those The criminal record should be wiped clean.
Maybe Sharon could maybe take some.
And this is specific in relation to children that have criminal.
It is, yeah.
I suppose it isn't something that we have specifically looked at in relation to this, because we were clearly looking at adult offenders and perpetrators. But what I would say is we do a significant amount of work with children and young people. So my own personal view would be that there has to be some serious consideration as to a point where we look at either a complete wiping the slate, or looking at the level of conviction prior to that and saying what should be removed and what shouldn't. And I'm assuming that that's for yourselves to decide, but I would think if there were significant crimes prior to 18, that would be something that should be ongoing on the record. But if they were minor, I would think it would be something that shouldn't carry forward to them for their adult life.
Sorry, and also, I'm right, Chair, can I intercede?
Yeah, go ahead, Mr. Free.
Just on that point.
I'm going to let members cover all of the aspects. I'm not going to do it section by section. So
I don't think you've got any, because if you're not maybe finished,
I'm
just
finished.
on that point, and before I lose my train of thought, it's getting late. You say the seriousness of crimes, but what about type of crime? You know, if there is a minor involved in domestic violence, sexual violence, is there merit there to keep something like that on record? And wipe the slate clean of everything else, or other types of offences?
I suppose I should have been clear. In my mind, when I was saying minor and more serious, I was thinking about types rather than actual. So I would say around violent and sexual issues would be the two issues that would jump out at me personally as something that there'd have to be serious consideration if we wanted those to disappear for somebody at the age of 18. So that would be my own personal view. But I have to say, whenever we were looking at this, we were looking more from adult perpetrators of domestic violence.
If I could add a point to that, I just think it's also maybe pertinent to make the comment that you'd be hard-pressed to find a young person in the offender system who hasn't actually experienced domestic violence within the family themselves.
Yeah.
You know, a lot of the work that we do with children and young people recognises that even if a child is not directly abused in the home, even as a witness of abuse, the amount of trauma and you know, other impacts on their education, on their well-being, on their health, on their abilities to function in society, on their abilities to form relationships, to excel at school and so forth, are really seriously impacted. And some of that, acting out or reacting to the very grave situation that they are in within their family homes, can sometimes spill out and result in them being in some level of criminality, whatever that is. So I do think that there is a sort of a rounder view to be taken on that with regard to how that can impact upon children.
I know you have a list there. I'll go to the end of the list, Chair, and you move on.
Mr. McGuinness.
Thanks very much, Chair. Chair, I have to leave in a few minutes. Does that matter in terms of the quorum?
Well, in terms of actioning things, the meeting can go on, but we can't then action anything.
Yeah.
Would be the difficulty.
I know you would.
He got in before me.
Sorry. First of all, thank you very much for your contribution. Very interesting, very helpful, and I just want to pay tribute to the good work that you do. Just in relation to the prosecutorial fines, you want domestic violence exempted from that? Is that your bottom line?
I think so, yes.
Yeah, and it's a red line for you that way, is it?
Yeah, just, given the absolute, disparity between what can actually end up in court and be convicted, the amount that it takes for a victim to even be able to get to the point to do that versus the reality of what the abuse is.
Yes.
We would say that, we have people who are in Maracks who are high-risk offenders and who are a real threat to victims, and they don't have a blemish on their records, or they have something very small. So sometimes if it's got a domestic motivation, sometimes it's it could be the difference.
So it's a hidden thing.
Absolutely.
And that's the danger they're in. And just on the VOPOs, I suppose you call them, you see them as a necessary tool in combating domestic violence, do you?
We certainly see something along those lines as necessary. At the moment, there is a gap in terms of dealing with serial perpetrators. We know that a lot of perpetrators do move on from one person to the next person to the next. Again, Sharon could maybe speak to that in more detail. But we know that this happens, and at present, while we can take them, we can refer a woman to a MARAC or refer a victim to a MARAC, something else does need to be there in order to prevent that impunity and that serial perpetration, to break that habit from being able to continue, and for more victims to continue to be abused. So something needs to be there. I suppose our comment would be just that we don't think that in its current form those particular orders, given the threshold, will cover an awful lot of the cases that they'll probably be needed for, where there are serial perpetrators in Northern Ireland.
Chair, I'm afraid I do have to go. Sorry.
Have you 5 minutes?
Yes.
Well, I'm going to stop this session and move. There's 2 legislative consent motions that we do need to put through. So if you're happy to stay at that end of the table, we'll come back to this. I'm going to move on to the legislative consent motion. So there's no decision needed on that, on either of them. Let me just do it anyway. The legislative consent motion is on pages 76 to 121. This is in terms of the Modern Slavery Bill. The draft motion that's being tabled by the Minister of Justice reads that the Assembly endorses the principle of the extension to Northern Ireland of the provisions of the Modern Slavery Bill as brought from the Commons to the House of Lords on the 5th of November 2014, dealing with enforcement powers in relation to ships, as contained in clauses 37, 38, 39 and Part 3 of the Bill and Part 3 of the Schedule 2 to the Bill, the Independent Anti-Slavery Commissioner in Part 4 of the Bill, and the transparency in supply chains in Part 6 of the Bill. The committee was briefed by officials at the meeting on the 5th of November on the provisions of the Modern Slavery Bill that would extend to Northern Ireland, and that covered 3 main areas: provisions introducing new enforcement powers in relation to ships in order to tackle human trafficking and slavery where they occur at sea, provisions under Part 3 of the Bill to establish the Office of Independent Anti-Slavery Commissioner, and then provisions to enhance transparency in supply chains. The LCM also set out a number of reasons for using the LCM instead of legislating through the Assembly, and these are outlined in the meeting folder. The committee has considered on a number of occasions the UK-wide Anti-Slavery Commissioner in the context of the Human Trafficking Bill and the Northern Ireland Rapporteur. The Department has advised that if enacted, it's anticipated the Department's contribution to the cost of the Anti-Slavery Commissioner would be in the region of £20,000 to £30,000 per annum. So it is to seek members' views on that LCM and if they're content to support the draft motion. I know I've engaged with Lord Morrow on this, and obviously he's been heavily involved with the department. He has expressed to me he is minded to go with the department and the approach that they have outlined in respect of this. So it's whether members have any particular views to form the draft report that we would then need to submit as a committee that would then come to next week's meeting.
Content.
Okay.
Yeah.
The other LCM is in respect of the Serious Crime Bill, and again it's to try and establish the committee members' views on this for its report. There's a draft motion that the Minister is bringing forward, and that is that the Assembly endorses the principle of the extension to Northern Ireland of the provisions of the Serious Crime Bill as amended at third reading in the House of Lords, dealing with the proceeds of crime, and that's contained in Chapters 3 and 4 of Part 1 of the Bill. Proposed changes to the Serious Crime Act 2007 as contained in clauses 45 to 49, the possession of a paedophile manual in clause 66, and female genital mutilation in clauses 67 to 70. The provisions of the Serious Crime Bill extending to Northern Ireland cover 4 main areas, and that's proceeds of crime legislation. These proposals are not a fundamental change, but rather a tightening of aspects of the current system so that it operates as originally intended. The Department indicates that extension to Northern Ireland would ensure consistency in the operation of this complex legislation.
Secondly, serious crime prevention orders, consolidating the financial reporting order within serious crime prevention order and increasing the penalty for failure to comply, extending the time limit of such an order and extending the order range of serious offences. Thirdly then is obviously around the female genital mutilation, a number of additional and new offences as part of a general move to address this crime across the United Kingdom. And then finally the paedophiles manuals, and this is a new offence aiming to criminalise the possession of material containing practical advice on how to commit a sexual offence against a child. Since the committee last considered this serious crime bill in July, there were some additional amendments in relation to asset recovery and around female genital mutilation have also been introduced, and they've been highlighted for members. The LCM also sets out a number of reasons for using the LCM approach instead of legislating through the Assembly. There's been a paper received from the Department earlier this morning, and that outlines that the Minister has requested an amendment to the bill on behalf of the Executive, and the Home Office has agreed to make that. When the Executive, a paper on this bill was being considered, there was a human rights point raised about the proceeds of crimes provision. This concerned safeguards and proposed clause on the change in the conditions for the exercise of restraint order powers under the Proceeds of Crime 2002 Act. The clauses lower the test from reasonable cause to believe to reasonable grounds to suspect. The report of the Westminster Joint Committee on Human Rights found that the Government has adequately justified the lowering of the threshold for restraint orders. The Joint Committee did suggest that while there were adequate safeguards in place, some of them were judicially implied and could be made explicit in the legislation order in order to give greater legal certainty. In light of the views expressed by Executive colleagues, the Minister wrote to the Home Office asking that they should amend the Act accordingly, and the LCM has therefore been amended and will read as follows. This Assembly endorses the principle of the extension to Northern Ireland of the provisions of the Serious Crime Bill as introduced in the House of Commons on the 6th of November, dealing with the proceeds of crime as contained in Chapters 3 and 4 of Part 1 of the Bill, proposed changes to the Serious Crime Act 2007 as contained in clauses 45 to 49, the possession of a paedophile manual in clause 66 and female genital mutilation in clauses 67 to 70, and agrees that Parliament should consider amendments to the bill to make explicit in statute common law safeguards in relation to the exercise of confiscation order powers under the Proceedings of Crime Act 2002. So whether members have any particular views in respect of that, otherwise the report will indicate the committee's contentment. Are members content?
Content.
Okay, they're content. Are they the two items?
Yeah, we can defer.
Okay. The rest can be deferred.
Chair, there was just one item of correspondence I wanted to talk about, but could it be deferred until next week?
Well,
it relates to the Law Commission.
What we'll do is we'll defer all of the other items.
Yeah.
Well, the other items can be dealt with next week.
Part-timers.
Thank you for staying, Olwell. Okay, let me go back and bring in Mr. Lynch. Sorry for that interruption, and I appreciate it's slightly upset proceedings, but however, Mr. Lynch.
You still want to be on the Justice Committee? I think it was yourself, Louise, mentioned delays. What would you put down, or where do you think the causes of the delays lay? Is it with the court process and or with the PSNI? And regarding, you were saying that training needs to take place, whether that's with the criminal justice system, you were saying, or intimated that they see it as incidents rather than it is often a pattern. And in terms of people rates of convictions, I think it's a very, very low rate. I don't know what it is here, but it is one of the crimes, a very low rate of reporting, low rate of charging, and even less conviction.
And just on the first one on delay, if you have any comments about how you're finding it in your area?
So there are two things that happen. One is the it was mentioned earlier, I think the Law Society as well, about the length of time to investigate, the length of time to get forensics, so there's those practicalities. But there's also the issue of perpetrators not attending court, etc. So that comes up on a range of occasions. Before I came here today, I had spoken to one of my staff to see about a couple of examples, and in one case, case of AOABH that happened in January, it's coming to court in November, has been adjourned since May, so that goes on and on and on. Attempted murder case that happened in April, we're 7 months later. There's not even a date set for court, so it hasn't even got to the point of being adjourned. So even just the processes of the court itself before it even gets to the opportunity for a perpetrator to potentially not turn up and provide difficulties along the way. So put the two of those together and you can have significant delays and significant negative impacts on victims attending court, and significant more likely for them to get to a point where they say, do you know what, I'm withdrawn, and that's it.
I suppose I would add to that that, it gives, every delay gives a perpetrator the opportunity to exert control and manipulation, coercion, in order to frustrate the case, in order to see that justice isn't done. And that we believe that delay, it's not just a victim's issue, it's also a best evidence issue as well. The more confidence the victim feels that they have in the system, and the safer they feel, the better they're able to give evidence, and delays do impact negatively upon that, for all the reasons that Sharon had mentioned.
Can I just say as well, one of the things that we had said at the very start was that the criminal justice system was justice system centred, justice agency centred rather than victim centred. You get regular examples of court cases at some quite considerable distance for victims to travel, known about for weeks and weeks and weeks, and you can be told on a Monday that you were supposed to be in court on Friday, but we're bringing it forward to Thursday. So, right, and what? But whenever that impacts on the victim, and that impacts on solicitors, on barristers, any support agencies, and then forget that you add into the fact that an individual may have 4 or 5 children that she has gone to considerable length to have looked after, etc., moving something forward a day makes a huge difference, and there's no leniency given for victims. As far as we can see, once things are changed, they're supposed to be there, so that's why we would be very clear that it isn't, the first thought isn't how will this impact on the victim. It is how can we as a system make sure that we've got an empty spot there, or somebody's taken a Friday off, or something has happened. And of course they don't want it to be adjourned and adjourned and adjourned, but even those type of things, it's the attitude.
And would you see the Victims' Charter having a positive role to play in that process?
Yes, I think it should, as long as we are clear that we try in every single instance to have a look at victims in 2 ways. One, how is this going to have an impact on any victim, but then in relation to domestic violence, having a better understanding of the actual nature of domestic violence, so that we're not treating all victims as one homogenous group.
Just on your comments about training needs, to answer your question, yes, a lot of the criminal justice agencies, police, so forth, tend to look at domestic violence incidents rather than as part of a whole pattern. I suppose it's fair enough in the sense that, police are there to deal with an incident. What we would say, I suppose 2 things, is that, with training, the entire, all criminal justice staff, agencies, judges, police, if they're enabled to understand the pattern of abuse, the fact that not every, it's not just criminal incidents, not just physical incidents, there is psychological coercion, control. It's not bad all the time. There is a reason why victims stay. Also, there is a reason why they stay in terms of the fact that they're not necessarily safe if they go. If all those things are understood, I believe that everyone is able to do their job more effectively, confident in the knowledge that they know what they're dealing with. Also, we do appreciate that, police aren't social workers, they have a job to do, and that's why we would say that That is why, at the earliest possible opportunity, referral into specialist services who are able to round off that square and be able to pick up the rest of those aspects and make sure that the victim is getting, all aspects of support that they need, and making sure that the whole picture is understood. That's why that is particularly important. And so you had a question about rates of convictions being very low as well. Yes, like we said, we have people, we would sit at Mareks, and there will be a lot of high-risk victims who are serious, and Marek is only high risk; it's serious risk of injury or death, and the perpetrator might not have any criminal convictions at all. Like we already said, it does take an awful long time for some to be reported. In our anecdotally, we have found as well that even those who be supported in our services or on the 24-hour domestic and sexual violence helpline, even maybe the most serious aspects of the abuse, for example, sexual violence within an intimate relationship, some victims may never be able to speak about it. There are some things that are just so horrendous and have had such a traumatic impact that it takes a very, very long time, or perhaps never, that people talk about it. And we need to recognise that the criminal justice system, as it is now, and just having those physical crimes, being the crimes, aren't covering everything. And that there is a government-recognised other side to domestic violence. Like if you look at the strategy, there is that recognition of the psychological, the financial abuse as well. We do have to understand that there are other elements, and that as well, it does spread out not only to the civil courts with regards to non-molestation orders, but also to the family courts in terms of contact proceedings, in terms of divorce and separation. That domestic violence does impact there, and that there needs to be support and understanding there as well.
Okay, Mr. Free.
Yeah, with regards to the FOPOs or post the violent offences, is it your thinking that we need more defined prevention orders for domestic violence or sexual offences? So we would have a range of prevention orders, or will the one violent offences prevention order do everything?
I think for one to do everything, you'd have to seriously look at those thresholds. Obviously sexual violence is per se a serious crime. Domestic violence incidents are not. And as we've alluded to, that not everything is covered there. So I suppose the committee would probably know better than I, but either you would need to rework the VOPOs to be able to take into consideration all those different elements, or in the alternative, something that is more tailored to domestic violence could be put in place. I guess the issue that we've always found is that because there is that unique element with domestic violence, with that relationship, that it's not a stranger committing a crime against a stranger. There are repercussions and there are differences. And there are also differences in the way a victim may react, because at the end of the day, they are in a relationship or a family member, So those things need to be taken into consideration, and that element of abuse and of control and manipulation do need to be taken into consideration as well, and that victim protected even more so. So, I don't think I would have any particular comments as to one or the other, but definitely something would have to be tailored to be able to take into consideration all the circumstances.
So you have a range of prevention orders that do different things, and carry less or serious consequences. Would you be happy?
That isn't what I was hearing you say. Is that fair? Sorry, I'm apologising if I've picked you up wrong, because one of us has. You were talking about a range of different VOPOs.
Well, either a range of different types of order, or the VOPOs to be more tailored. To be tailored, or to sort of widen to encompass it and not have that threshold that is prohibitive.
But does that necessarily mean a change of name type, or a set of different initials? For a face of a bill, or for how do you get that nailed down? To me, you need to have specifically different orders to cater for the different aspects of crime that you talk about.
Well, I suppose, not every criminal activity that's related to, that has a domestic motivation, is a violent crime per se. You know, like we said, there are things like criminal damage. There
Yeah.
are, you know, there are other things that maybe that are wider than that. Obviously, assault is a massive one. But so you know, if it's a matter of like the name of it reflecting something, perhaps it is the case that, you know, there should be something about domestic violence out there. But I suppose we haven't thought through in particular detail beyond what we've sort of discussed through the PANI victim advisors and PERP.
I hear what you said earlier about the impacts of domestic violence, and an act might be perpetrated once, and then other minor things that aren't breaking the law after that will be the threat, which could impact just as much then as the initial act of violence towards a person. You know, so it would be bullying, you know, it would be a threatening, it would be an action that won't lead to a crime being committed, but will, you know, will impact the same.
Yeah.
How do we nail that?
Well, I suppose that's why we mentioned in the future the hope that coercive control would be something that would be seen as criminal.
Right.
But that's not the position that we're in right now, but it would be something that Women's Aid would be advocating for in the longer term. I suppose the other thing that in relation to the VOPOs was one about the repeat abuse within a single relationship, but then secondly about the serial offenders that Women's Aid have had experience of over the last 40 years, but I think it's been brought into sort of stark relief with the MARACs that happen across Northern Ireland every month, and the realisation that there are extremely dangerous perpetrators who have appeared and do appear time and time and time again with different victims and very serious incidents there, some with criminal convictions, some not. But I suppose for us as well, it would be looking at if they have a low level that doesn't reach the threshold for the VOPO, how do we look at somebody who has repeated low-level offences that we are all linked to domestic violence, in the knowledge that the nature of domestic violence is that it is not one instance in a relationship, that it is something that is repeated, etc., and has a significant impact. So how do we look at that and say, we know as a society, we know as Women's Aid, we know as PSNI, we know as social services, probation, etc., etc., everybody that sits around the table at MARAC, we know that once this particular name happens and is said, that we worry how long it will be until we believe it is highly likely that that particular individual will be on MARAC again because they're in a new relationship. So if all of these statutory organisations and voluntary organisations such as yourselves can see that, then, but their criminal convictions are of too low a level to have a VOPO, how do we look at those and say, what is the threshold for how many times does that happen before we say that's enough to meet the threshold for the VOPO? So that'd be another way of looking at it, I suppose, at this particular time.
Okay, thank you.
Thank you. Can I thank you both very much for coming to the committee? Apologies for the delay and the interruption. It's the nature sometimes of committee business, so thank you very much for your time.
Thanks for your time.
Okay, members, we'll defer the rest of the agenda to...
This is the Northern Ireland Assembly Committee Room 21. This is the Northern Ireland Assembly Committee